Welcome to the seventh hearing of the Select Committee's inquiry into the proposal to raise the Warragamba Dam wall. Before I commence, I would like to acknowledge the Gadigal people who are the traditional custodians of the land on which Parliament sits. I also acknowledge the traditional custodians of the various lands on which my colleagues are joining today, as well as people participating in today's hearing. I would also like to pay my respects to elders past, present and emerging, and extend that respect to all Aboriginal people who may be present today. Today's hearing is being conducted as a fully virtual hearing. If participants lose their internet connection and are disconnected from the virtual hearing, they are asked to rejoin the hearing by using the same link provided by the committee secretariat. Today, the committee will first hear evidence from the Colong Foundation, then hear evidence from agencies who have been responsible for or involved in the review of the environmental impact statement for the proposal. Before we commence, I would like to make some brief comments about the procedures for today's hearing. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the virtual hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have the right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days. Today's proceedings are being streamed live, and a transcript will be placed on the committee's website once it becomes available. Finally, a few notes on virtual hearing etiquette to minimise disruptions and assist our Hansard reporters. Can I ask committee members to clearly identify who questions are directed to, and could I ask everyone to please state their name when they begin speaking? Could everyone please mute their microphones when they are not speaking? Please remember to turn your microphones back on when you're getting ready to speak. If you start speaking whilst muted, please start your question or answer again so it can be recorded in the transcript. Members and witnesses should avoid speaking over each other so we can all be heard clearly. I remind members and witnesses to speak directly into the microphone and avoid making comments when your head is turned away. I now welcome our first witness, Mr. Andrew Chalk. Mr. Chalk, could you please state your name and position title and swear either an oath or affirmation?
Thank you, Chair. My name is Andrew John Chalk, and I'm a solicitor, a legal advisor to the Colong Foundation. And I, Andrew John Chalk, swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Mr. Chalk. Would you like to start by making a short opening statement?
I will, Chair. Thank you. Firstly, thank you to the committee for the opportunity to speak today. I am here in a fairly narrow respect on behalf of the Colong Foundation, and that is that while the Colong Foundation has made a very detailed and lengthy submission on the environmental impact statement for the dam, my role in that was limited to looking at issues around whether the EIS itself met the legal requirements for an EIS under the Environmental Planning and Assessment Act. And so while the submission dealt with many other aspects of the EIS, the Colong submissions, Foundation submission dealt with many other aspects, my comments will be really limited to the legal aspects. I should also say that that the Colin Foundation has waived privilege in the advice that we've provided to it in relation to the validity, if you like, of the EIS, and I'm authorised to speak on those aspects. The crux of the advice that we gave the Foundation, and which appears in large part in the submission that they made, was that the document that was exhibited as an EIS doesn't meet the legal requirements. And the essential reason for that is that there were key and critical parts of the proposal that was put forward that as yet haven't been resolved or defined in a way that would allow an effective assessment of the impacts that the proposal would have. And just in brief summary, the elements that go into determining the performance of a dam in a flood, in their crudest form, comprise the amount of water coming down the river or the stream, the height of the dam wall, or more specifically, I guess, the height of the spillway, whether there are openings in the wall, apertures, slots, conduits, and where those apertures are positioned and their size, and also whether they're gated in order to allow the dam actually to be operated. And thirdly, if they are gated, whether or how those gates are actually operated in the event of a flood. Now, in the current instance, the proposed height of the spillways has been identified, but the other two critical elements, the apertures or openings, haven't been determined, or whether they're gated or not, and assuming that they are to be gated, what the operating procedures for the dam would be. And those two elements are absolutely critical to being able to determine whether or what the impacts of the proposed new dam will have on both the upstream and downstream environments. And so, in effect, if a development has three parts to it, the current EIS really only effectively deals with one. And in those circumstances, it sits so far outside what might reasonably be expected for such a critical piece of, or such a critical development, given the potential impacts that it's intended to either ameliorate or potentially cause. And for those reasons, in a nutshell, we just say that it doesn't come close to meeting the what is a very high bar for saying that a document doesn't constitute an EIS. So I might leave it there in opening.
Thank you, Mr. Chalk. I might open with some questions. My reading of the advice that you've provided to Colong, if I can summarise and get you to respond to, is basically the proponent has failed to meet the requirements of the planning law in New South Wales about what should be included in an EIS, and therefore it is impossible for the planning minister to lawfully make a decision about this project given those inadequacies. Is that correct?
In summary, that's correct. And the project is defined as including both the physical infrastructure and how it is operated. As I've just mentioned, the key aspect of the physical infrastructure, aside from the height of the spillway, which is what gates or apertures there will be in the wall, haven't been defined, and therefore you don't get to the second stage of how are you going to operate it. So at very best, if it were just a weir, you could get approval to construct it as a weir, but that's not what's being proposed here.
So the EIS does articulate impacts upstream and downstream. It articulates flood mitigation likely outcomes, but if I'm understanding you correctly, it's actually impossible for the decision maker to make a determination about whether or not those claims are accurate or reflect the full extent of impacts, because they've provided no detail about how the actual dam wall would operate in a flood.
That's correct. So the EIS poses three options in relation, for example, to opening. They say we might build openings or conduits that are gated and where those gates can be operated. We may just leave the gates the conduits open so that once the water reaches a certain level, it flows out as fast as those conduits will allow. Or thirdly, it may be a combination of the two. But the essential point is, if you put an obstruction in the middle of a river, then the only way you're going to know what effect it's going to have upstream or downstream is by the technology that allows the flows to be controlled. And if they haven't decided whether or not those flows will be controlled, and if so, how, then it's impossible to work out the upstream or the downstream impacts, for that matter, other than on the assumption that it's just a weir. But that's not what they've done in their EIS. When I say a weir, I mean a complete blockage of the river to a certain height so that the water just can do nothing but flow over the top. So, for a piece of infrastructure that is intended to cost so much, and that is to have, it's said, such an important and dramatic impact on how floods occur in Western Sydney, or the impact that it's going to have on Aboriginal cultural heritage upstream, as well as biodiversity and vegetation upstream. The idea that these fundamental elements haven't been resolved makes it impossible to assess those impacts.
Just one more question from me before I hand over to others. What are the legal consequences should the planning minister approve this project on the basis of the current EIS?
But I think inevitably there would be a challenge to it, and the minister would be left in a position of having to defend why a project that left 2 out of 3 critical elements unresolved has been given approval. And I know there's some suggestion that a solution to that might be by the path of using a preferred infrastructure report, but that misconceives the role of those reports. I mean, they're really meant to be sort of the fine-tuning of a proposal based on the submissions and the reflections and the work that comes out of the EIS and the responses, the public responses and departmental responses to them. But if you haven't defined the critical elements of the project, you can't really play the catch-up in the preferred infrastructure report and hope that that will be adequate. Not least because it's a fundamental requirement that you have a proper EIS exhibited, and if the EIS hasn't met the Secretary's requirements, which we would say is the case here, then you just really don't get beyond that point. So I can't see the Minister's decision to approve on the current EIS being valid. I think the answer really is essentially that the Water New South Wales needs to go back through what it actually wants to do and how it will do it and what the operating procedures and protocols would be, and then put that on exhibition. It doesn't mean starting again, but it does mean a new EIS and a new process if it's going to be done validly.
Okay, thank you, Mr. Chalk. Deputy Chair, any from you?
Sorry, not at this stage, thank you.
Opposition?
Yes, I've got questions. Thank you very much for coming in today, and thank you for the information. I just wanted to, so in particular, I just wanted to get you to outline to the committee why you believe that the Secretary's requirements, the SEARs, haven't been met. So just for Hansard, it's the Secretary's Environmental Assessment Requirements, SEARS. Can you just take us through why you believe those haven't been met?
So the first one is that and it's requirement 2.1b, the proponent must detail a framework for managing water releases from the dam that are capable of meeting the objectives of the project in terms of flood mitigation and ensures impacts to upstream and downstream areas and ecosystems are minimised. The framework shall include consideration of the potential rates of rise and fall in the river, timing of water releases. These shall include consideration of antecedent conditions within the river, flooding impacts and transparent and translucent flows. The requirements require detail about the project. And as I've outlined before, that if two of the three fundamental aspects of the project haven't been defined, you don't get to that most basic of requirement. But there are other failures in terms of meeting the SEARs. One is that the proponents required to consider not only alternatives to the project, which might, for example, be a better road network to allow escape, or dredging the river to improve flows, but they're also required to consider what the options are within the project. So in other words, let's assume we're going to raise the dam wall, or we're going to operate it in a particular way. What are the alternatives to how we operate it? And if you haven't defined how you can operate it, you just don't get to defining what those options are. So the irony is, you probably couldn't build a granny flat in Western Sydney without hydraulic engineers' reports on what your options are. This is a project that's meant to secure the safety of Western Sydney in the event of a serious flood. And yet these core issues haven't been determined. So
no, thank you for that. Yeah. Thanks. I just wanted you to outline sort of that. That's been helpful. I mean, the other part of this, of course, is so in terms of what the government does from here, they're basically heading towards doing a preferred infrastructure report. And again, can you just explain to the, my understanding of that is that sort of, is it your view that, I mean, except what you've said before, which is that the EIS is inadequate, so in some ways they really shouldn't be proceeding at all, but is it your understanding that really the way the government is trying to deal with the considerable criticism of the EIS and the likely impacts is through this slightly separate process now, which is the preferred infrastructure report? Can you just take us through I suppose the key decision-making points in where that fits in the approval process and why it's outside the Act, which I think that's basically your assertion.
Probably, pardon me. Probably the fundamental reason that we say it's outside the Act is that an important part of the EP&A Act, and one of the consistent themes of the Act, is public participation. It's one of the objects of the Act, and it's always been there. Now, admittedly, state significant infrastructure eats as a Part 5 Division 5.2 eats into what otherwise would be the normal public participation requirements. But that's in one sense why the EIS process, which is so important, as really the only opportunity that the public gets to look at what the government is proposing to do, or what the proponent is proposing to do. If the scheme is essentially subverted by putting in a minimal EIS, it doesn't detail critical aspects, and then slots them in down the track at the preferred infrastructure stage, which doesn't have to be exhibited. You really cut significantly into people's ability to comment on the project, including experts and other departments for that matter. Now, I should add here that the impacts won't only be upstream from the operation. Depending on how the dam is decided, or how they ultimately decide to operate the dam in a flood, there will be people downstream whose properties will be inundated for longer than if this wall was built. So there will be losers and winners downstream as well, and yet they won't have the opportunity to comment on who should win and who should lose, because they won't get to see the operating protocols in advance of the project proceeding, if that were a lawful way to do it.
So essentially, the government's looking at doing this preferred infrastructure process, which carves out, from what if I understand what you're saying correctly, carves out, public input into that process, and then basically, and it would then, it's still, the minister could still basically approve the project, leaving aside the fact that you think that it could be challenged and those kind of things. But the process, as you've described it, means that essentially the minister could still go ahead and approve the project. Is that right?
Well, he could attempt to. I'm not saying the challenge
would
wouldn't
be
be
a challenge, sure. Yeah. No, that's sure. I don't know. I get that. The backwards and forwards. I mean, the key issue here is there's a requirement for legislation to change the operational aspects of the wall if they're to use it for flood mitigation. Isn't that correct?
So I understand that, and I gather Minister Ayres may have made a comment to that effect, and that is also relevant, because to the extent that it can't be used for flood mitigation at the moment, and I'm not saying that's the case. It's not something that I've looked closely at, but the premise of the whole application is that no, this project won't be used for storage. It's or water supply. That its function is purely flood mitigation. If that's not the case, and legislation is required to address it, then yes, you would assume that the legislation should precede the exhibition, or certainly the approval of the project, or at worst make the commencement of the project conditional on the passage of that legislation.
Yeah, thank you. If others have got questions, I've got more, but I'm happy to see if anyone else has any at this point.
I'm happy
I
for you
might
to
just
continue,
ask,
Penny.
I might just ask government if they've got any questions, and I just flag we might spend a few extra minutes with Mr. Chalk since we started late. Government, any from you?
None
Then
from
Ms.
me,
Sharp.
Chair.
If that's the case, I'll jump in.
Go for it.
Thank you. I know that there's also been concerns about the way in which the summary report of the submissions to the EIS has been dealt with and has been raised by Colong, and that's really to deal with about, I think, over 500 submissions that have been not properly addressed. Do you want to take us through that issue, please, Mr. Chalk?
So essentially what happened there was that I think the Colon Foundation set up a website that guided people through gave them the opportunity of making submissions via that site. I think there are just over 500 submissions made in that manner. The department decided not to treat them as submissions, but instead to treat them as what it was calling feedback. Two grounds were given, as I understand it. One was that the proper or a disclosure of political donations had not been in the form that the department preferred, and the second was that privacy requirements and whereby Privacy Act requirements where the maker of the submission would tick how they wanted their privacy treated, and an acknowledgement of the department's terms had also not been met. And we would say that neither of those are valid reasons to reject the submissions. Firstly, there's no such thing as a feedback under the Environmental Planning Assessment Act. It's either a submission or it's not. In relation to the political donations, even if a donation is not declared, it's still a submission. It may have criminal consequences for the person making it who doesn't disclose, but the submission still stands, and it obviously goes to the weight that's given to it. In this instance, though, the declaration, if you like, that was made on the Colong's website was wider than what the department requires. So the fact that the department requires a narrower declaration, a more limited declaration, doesn't avoid the fact that a wider one was given. And in relation to the privacy issue, submissions contain very little private information other than the name of the person making the submission. They're just expressions of opinion. And so those could very easily be dealt with, if need be, by just deleting the person's name on the assumption that they may not want it published. But there's no basis for not treating such a significant number of submissions.
Thank you. I've just got one. Thank you for that. I've just got one more issue, which is I understand that you've provided legal advice on, in relation to these matters, and you've been talking about that a lot. Are you okay to table that for the benefit of the committee?
Yes, I've got no problem with. There was a written advice of 20 January 2022. There's no difficulty tabling that.
Yeah, terrific. Thank you very much. If we can get a copy of that, that would be very helpful for the committee. That's it from me, Chair.
Thank you, Ms. Sharp. I might just check with government if there's any last questions. If not, then thank you very much, Mr. Chalk. Sorry, Wes, was that one from you?
Oh, no, I was just going to indicate, Chair, that we've just been listening intently, but we're happy with what we've heard so far.
Okay, thank you, Mr. Fang. Mr. Chalk, thank you for your evidence today and agreeing to provide that document. The Secretariat will be in touch about that. Thank you for your time.
Thank you, Mr. Chair.
Okay, I'd now like to welcome our next witnesses to today's hearings, Mr. Simon Draper and Ms. Marie Abood from Infrastructure New South Wales. Mr. Draper and Ms. Abood, as you have previously given evidence to the committee, you'll be examined on your former oaths or affirmations for today's hearings. But I'd also welcome you if you would like to make a short opening statement.
Thanks, Chair. No, we don't have an opening statement today.
Okay, thank you. Then look, I might commence with questions if I could. We've just received evidence from Mr. Andrew Chalk, who's provided legal advice to the Colong Foundation. The suggestion that he's made and provided advice to the Colong Foundation on is that the EIS fails to fulfil the requirements of the SEERS, the Secretary's Environmental requirements for the project. This is an issue that has come up before within the committee, including the leaking of information from various government agencies that suggested as far back, I think, as 18 months ago, that the draft EIS was inadequate in terms of the Secretary's environmental reporting requirements. Could I just ask you to provide a comment or response on this legal advice that makes that suggestion that the SEERS have not been met by the EIS?
I'll go first, and Marie may want to comment as well. Obviously, we haven't heard that evidence. I haven't seen anything from the gentleman you were referring to, but in any case, we're probably not the best place to comment on them, whether the EIS meets the requirements. I mean, obviously, the view of those who submitted the EIS at the time was that it did meet those requirements, and we are aware that there was a lot of engagement leading up to the submission and exhibition of the EIS, and it was checked by the Department of Planning. So on that basis, there was a prima facie view that it does meet the requirements of the SEERS, but clearly people can make submissions about that, and the department and the minister can consider those.
Well, now the project is in the hands of the planning department and the planning minister, and the proponent, Water New South Wales, has provided that EIS. Other agencies have commented. Can you just explain your role with this project going forward?
Going forward, well, maybe again, I'll start, and Ms. Abood can add to it. But our role generally is as the coordinator of the overall Hawkesbury-Nepean flood mitigation strategy, which has 9 elements to it. The dam is one of those elements, and I won't go through all the elements and waste the committee's time, because I think we've been through that before. But the dam is one element. The proponent of the dam is, as you said, Water New South Wales. And we'll continue to play a coordination role of this with all the other elements as well, provide advice and input, as do other agencies on the way through. As I understand it, it's intended that it will be delivered by Water New South Wales. I don't know, Marie, if you want to add to that.
Yeah, I guess our key role in, going forward is really around ensuring that the objectives of the strategy are being met, that any of the cost benefit information that we've provided, and so there's just, I guess, we Infrastructure New South Wales undertook the options assessment, so it's just any further advice that's required. We will support Water New South Wales in their submissions report, but that's our key role.
One of the aspects that was has been raised before by the committee and was also identified in the previous evidence, and I think has been included in submissions, including from the Colong Foundation to the project, is the lack of information about how the dam will actually operate under flood circumstances. Yeah, in terms of you providing advice, I mean, I guess where I'm getting to is you've been quite central in the discussion about this project up until now. You've faced hearings before. A lot of it, your comments, if I can put it quite simply, and I know we've had a lot of discussions, have been wait until the EIS comes out. The EIS is out, and now there's some serious gaps of information, including how the dam will actually operate, what the operational rules would be. And the criticism is that without that, other information around the upstream and downstream impacts simply cannot be reasonably assessed. So can you provide a response to that? And given that you're providing a coordinating response, how have we got to a situation where an inadequate EIS has been provided to the planning department?
Just on your last point, I mean, I think what we said earlier is we're not aware that it's inadequate or to accept that it's inadequate. That's a matter for the Department of Planning to determine. If they determine that, so be it. But as far as we're aware, it was entirely adequate. There was a lot of work done in preparation, and we're aware of the interactions that were happening between different government agencies to check that before it was submitted. And I guess, as you said, it'll be somewhat sorted out as part of the response to submissions report. As to the operating rules, I don't really have any comment on that. It's something that's sort of beyond our, or certainly beyond my, at least, areas of expertise. I don't know, Marie, if you want to make any further comment.
I think for further detail, I would suggest that you refer that to Warragamba, New South Wales. But what I can say is that there is a set of principles that were developed, and they were incorporated as the operational rules. And certainly, one of the key principles was to minimise the upstream impacts while maximising the downstream benefits. Dam safety, of course, is paramount. So there's a whole set of principles that were translated into operational rules into the modelling. So I guess, should the dam be approved, the operation will be, I guess, finessed. So it won't be any worse than what's been presented in the EIS. If anything, will be improved. So I would suggest that for further detail that you refer that question to Warragamba, New South Wales this afternoon.
Infrastructure New South Wales, I think, was quoted in a media story this morning suggesting that should the dam have been operating in the most recent flood event in the Hawkesbury Nepean, there would have been quite specific differences in the flood impacts at various points. I mean, you were specific to, I think, 0.1 of a metre. What were the operational rules that you used to base assumptions on to come up with that information, and why wasn't that included in the EIS?
It's the same operational rules that were done for the modelling for the EIS. So, as I said, there's a set of principles and a set of rules. So I'm not sure in terms of the operation what sort of details you're requiring, but I'd suggest that you would refer that to Warragamba, New South Wales this afternoon.
But do you concur that those operational rules are not outlined in the EIS? I mean, this is one of the fundamental criticisms that has been raised, that how the actual dam will operate is not articulated in the EIS.
I don't think we could, well, I certainly couldn't comment on that. I couldn't verify that then. I couldn't concur with that because I haven't gone back and checked whether that's the case.
Okay. There's been suggestions in the media in the past, and I think there's some correspondence that was leaked at some stage to this effect, that due to liability, questions around liability or concerns around liability with the operation of the dam as a flood mitigation dam, that there'd need to be enabling legislation. Can you confirm that that would be a requirement before the dam could actually operate as a flood mitigation dam?
I think there's probably two issues in there, Chair. The one I think was to do with the actual you need to have legislation that permits the dam to be operated as a flood mitigation dam as well as a storage dam. So that's one element. The other one I think you're referring to was a request from Warragamba, New South Wales. Is that correct?
Yeah, I think there's been a number of questions that have been raised around whether there's legislative amendments that are required to enable this function should the dam proceed. I guess that's depends on. You may not need legislative requirements because in the Warragamba, New South Wales Act, that function does exist. Certainly some regulatory amendments will be required, such as amendment of the water sharing plan, works approval, the operating licence, which is probably one of the key instruments. And there potentially could be a legislative amendment pending the liability, but that really would be, I guess, once there's a decision, then we would review the legislation and any regulations that may have changed in the interim to see whether any regulatory, legislative amendments are required. But nothing's planned.
With regards to the liability aspect, and Mr. Searle, I note your question. I might just ask this last one. You seem to suggest that may or may not be required. What would be the trigger for making a determination as to whether or not legislation, and I assume this is about limiting the liability of the dam operator, would be required? How would you make a judgment like that?
We wouldn't make a judgment on that. That's not really a matter for us.
It would be a legal process that we would go through, and we'd look at all, I guess, cases, Warragamba and all lessons learned, but and we've already looked at them, but we review them, and it would be up to, I guess, the.
Sorry, Chair, Mr. Booth. Sorry, you're just very muffled with your mask on. I know it's not your fault. I'm just really struggled to hear that last bit. My apologies.
No, that's okay. Look, yeah, sorry. I'll just sit a bit further from Simon. Sorry. What I was saying is, with the legislation, it would be reviewed pending the decision of the outcome of the dam. We'd be looking at all latest, I guess, legislative things and cases such as Warragamba, and really just to look at whether there are any requirements to strengthen legislation around liability. But it will go through any normal process, and liability. There's liability with anybody that's involved in this. So
I think obviously, I mean, this is an obvious answer, but that's really more of a matter for the Parliament than for us.
Yes, we understand that, Mr. Draper. I might, Mr. Searle, you look like you had a question before. I might throw to you in the first instance, and we'll move from there.
Thanks, Mr. Draper. Isn't Infrastructure New South Wales the proponent of this project?
Sorry, Mr. Searle, I'm just going to turn you up. I just can't. Would you mind starting again? We couldn't quite hear you.
Sorry, can you hear me now?
Yeah.
Isn't your organisation the proponent of this project?
No, the proponent is Water New South Wales. They're the applicant. We were responsible. If you're using a more generic use of that phrase, Infrastructure New South Wales led a process, probably going back nearly a decade, to look at the options for dealing with the flood risk in the Hawkesbury and Nepean Valley, and so we coordinated that process. But the proponent for the dam is Water New South Wales.
So they're the legal applicant, but you've been driving, as it were, the policy area. That's correct, isn't it?
Yeah, Infrastructure New South Wales is definitely supported. I mean, after there was a process of going through a number of options over a number of years, as Maurice Wood outlined earlier. The one that we recommended at that time as the most favourable and most beneficial was the dam wall raising. That's correct.
So the document the Chair referred to earlier was the Hawkesbury Nepean Valley Flood Management Task Force document. And on page 33, it says Water New South Wales would require amendments to its enabling legislation to provide a complete statutory limitation of liability to the operator, its directors, officers and employees. And then it talks about further comprehensive legislative requirements that would be necessary to fulfil the implementation of the raising of the dam wall. Are you saying that this is entirely a matter for some other agency and you haven't turned your mind to it whatsoever?
Well, I think what we're saying is that there's a view that a change in the operation of the dam may require complementary changes to other legislation that sets out the liabilities of those participants. But it is Water New South Wales. All of those references are to Water New South Wales, not to Infrastructure New South Wales. So I think that issue's been flagged, and the Chair's flagged that it's something that's been discussed in the past as well, but it's not something that refers to our organisation.
But it's not just about the liability of the operator. It's talking about the need to provide statutory authorities a comprehensive suite of documentation relating to flood manuals. Like, this is not just some small facilitative change in a statute. According to this document, some pretty comprehensive additional legislation would be required to fulfill the policy direction that you've led. You must have given some thought to that. I mean, are you saying that nothing will be thought about this until after any final approval is given, and then you'll work out what laws you actually need to implement this. That seems to be a recipe for disaster, having taken all this time and invested all these resources on this project. If you can't lawfully carry it out.
Now, the answer to that is no, that's not what's been done. So Ms. Abud outlined a few moments ago a number of the changes that have been anticipated. It's been a fairly thorough process. I thought you were asking specifically about the liability question.
I'm asking you about all the legislative changes necessary to affect this project.
Can I just add to that? So certainly I think the document that you're referring to, that maybe that was a point in time, and we've certainly done a number of reviews to look at, as I said, the current status of the legislative and the regulatory environment, and plus all the lessons learned, particularly coming out of Warragamba. So our role, particularly Infrastructure New South Wales, is to look at a whole of government perspective in terms of making sure that it's fair and equitable around liability. So yes, we do lead the policy, and we do coordinate across the government around the legal and liability issues. I guess the final, requirement, whether there is a legislative change that's required around the liability, will be, as I said, we'll do a reassessment at the time, but we do have a very good understanding of what's required.
Sorry, a reassessment.
We've done a lot of detailed work in this area, so it's not as if it is, as I said, the major changes will be really around the operational licence, water sharing plan, the works approval, and potentially there may be a legislative requirement that may be required.
Perhaps I'm not making myself clear.
You're a little bit faint, Mr. Searle. Sorry, I'm not sure we can't quite hear you.
It seems to me that there is clear evidence before this committee that at the present time, this project can't be lawfully carried out because necessary changes are needed to various laws. And I'm just asking you whether you agree with that, and at what point in time you're thinking about trying to achieve these changes to the law, because if you can't carry out this project under the law as it exists, isn't there the potential that all of these processes that are being engaged at the moment may be a futility if you can't carry this out under the law?
Well, under the law,
just to be clear, when you say the project can't be carried out, I mean the primary issue confronting everybody at the moment is a planning determination. So for the project to be implemented, for the construction to proceed, it requires obviously those construction approvals, those planning approvals. I think some of the things you're referring to go to the operation of the dam, the longer-term operation of the dam. And yes, those things have also been contemplated. But I agree with you that there's been no point in trying to change regulations or pass legislation through Parliament to deal with the operation of the dam when we don't even have a planning determination at this point.
No, I just add this.
Putting it the other way around, what is the point of obtaining the planning approval and potentially the very expensive construction if you can't lawfully operate in the way that's intended?
You can lawfully operate. There's no barriers at this point. The Water New South Wales Act function already exists. It just needs to be come into effect once there's a decision. And the key instrument there probably will be the operating licence. The Water Management Act. So the legislation's already there. There's no barrier to taking forward a flood mitigation function. It's just it's just assessing what additional things may be required, such as amendment to the whether you need a new operating licence or you amend the existing one. So there's no barrier to prevent a flood mitigation function.
And Mr. Searle, I think people could disagree with this, but I mean, if you think about the counterfactual to what you're putting to us, the idea that we would ask the Parliament to change laws and ministers to change regulations and go through that process when there's not even there hasn't been a public consultation and a planning determination made on the dam wall raising, that would seem the wrong way around. I think people would raise questions if we pursued that course.
Parliament was asked to change the law and did, I think, an election or so ago to facilitate this project. So the counterfactual that you put as being strange and perhaps unacceptable, in fact, happened.
Yeah, well, maybe that's
put forward by the government, of which you're an agency.
Oh, well, just to be clear, we're an agency, we're not the government.
I can just,
I put it in that context, Mr. Draper.
So,
those are the questions, Mr. Chair.
I was just going to say the 2018 legislation that you're referring to the legislation prevented temporary inundation, so it would have been very difficult to take forward an EIS and for the planning minister to make a determination. That is why the 2018 amendment of the Water New South Wales Act took place. But what you're referring to around the operation and the liability is a very different matter.
Thank you, Mr. Chair. Those are my questions.
Thank you, Mr. Searle. I might throw to the Deputy Chair in the first instance.
Thank you, Chair. Look, I just have a couple of quick questions. The Hawkesbury Valley flood mitigation strategy identified a number of issues to alleviate the flood risk and management down in the valley, of which the dam, raising of the dam wall was only one. Others included limiting development on the floodplain and upgrading of the evacuation roads, etc. Wonder if you can identify, this committee's been going nearly 3 years, started in June 19. The issues of the valley have been well known for longer than that. Just wonder if you can identify for us, please, any significant upgrades to any of the evacuation roads in this 3 years whilst this committee's been sitting.
I'll pass over to Ms. Aboud in a moment, but just to perhaps add to this, some of the other things you've described are not so much alternatives to the dam wall raising, they're complementary measures. So there's sort of, as I said earlier, nine measures. The road evacuations, the land use approaches, the community awareness, all those things go together with the dam wall raising. So I'll pass over to Ms. Aboud on any information about the road upgrades.
Specifically, okay, so Transport for New South Wales is responsible for leading the road resilient package. So they're just engaging with councils now and commencing the work for the final business case. So originally in the strategy we identified, I think, around 40 priority road upgrades. And in the work that they've done over the last several years, some detailed investigations revealed that rather than spot fixing, you actually have to adopt more of a corridor approach or a systemic approach, because you don't want to fix up one area and transfer the problem downstream or upstream of the roads. So they've got around 100, just over 100 projects that they're identified, and they're working with councils. And I think there was a recent announcement that the Commonwealth government was going to co-fund the money for the final business case, for the planning works for the final business case. So that work is proceeding.
Right. So nothing concrete is in place at this point in time.
Yeah, look, I don't want to. I think Mr. Wood's referring to a package of road upgrades that have been identified out of this process. I wouldn't want to leave you with the impression we couldn't answer the question about whether there have been other road upgrades in those. There's been obviously plenty of work done in the roads in Western Sydney and on the floodplain over that period. Which Mr. Wood's referring to a particular package that's been worked up through this program.
But there have been some road upgrades in the area around Penrith, the off-ramp onto the M4, I think some upgrades on Richmond Road. So there definitely have been upgrades with flood resilience in mind, but the package that I'm talking about is a piece of ongoing work.
Well, taking it a bit further then, can you identify for us any changes at all in any planning mechanisms, anything that's put any limits in place for future development on the floodplain? What's actually happened there? Because that was certainly another thing that you have identified in your strategy.
Absolutely. So one of the big things that we've been working on is the flood evacuation modelling, and one of the key purposes of that model is really a tool for the government to be able to assess the cumulative impact of ongoing growth for the lands that have already been rezoned. And so as part of any development or any DAA mode of significance, they will come to us and ask for advice as to whether it's going to have impact. So, ongoing work around Penrith Lakes, for example, around the employment lands. So there's a lot going on in the space. This will all feed into the regional land use planning framework, which is being developed. So it's a big process and it's a long process, but certainly for us, managing the growth is critical to make sure that the road capacity, that we can maintain the evacuation capacity.
Yeah, look, I have nothing further. Thanks, Chair.
Thank you, Deputy Chair. Government?
I don't mind asking a question or two. Thank you, Mr. Chair.
All yours, Mr.
Thank you. Now, I just wanted to revisit that discussion from our witness, Mr. Draper, there regarding the, I thought it was a good line of questions from Mr. Roberts about the flood strategy. one of the perceptions that the community and the opponents of the dam wall raising have is that it's one or the other. It's a dam wall raising, or it's roads and evacuation routes and stopping any further development that might be permissible in the current planning regime. So I'd like you to unpackage that a bit more for us to explain to us why it isn't one or the other. In the view of the government, it's a strategy of a combined package of approaches, including community awareness, which we talked about before too.
Yeah, so I mean, I'll start, and Marie's by far the subject matter expert here, so she can take us through it more thoroughly. But I think that is a good. The way I describe this issue is it's one of those things. People talk about complex policy problems all the time. This is genuinely one that's complex because there's so many different competing goals. That we start obviously with the problem that there's a lot of people who already live and work on the floodplain who are very exposed to risks every day. You've also got to take into consideration the environmental impacts of some of the measures that can be undertaken. The dam wall raising has obviously raised a lot of concerns about potential biodiversity impacts, about Aboriginal cultural heritage, and many of the options also raise concerns about water security. So we've got the complexity around the problem. We're trying to solve lots of different objectives at once. And then there's a number of elements required to try and deal with the flood mitigation process as well. There are 9 elements. Again, I don't want to unnecessarily take up the committee's time, but I do think it's worth sort of explaining that they are complementary. They do not substitute for each other. By far, the measure that has the greatest impact in terms of providing time for people to evacuate and reducing the peak of floods is a dam wall raising, or alternatively, but less effective, other changes to the dam wall to allow people time to get out of there. So I'll pass over to Ms. Abud to perhaps step through what are the other elements.
I guess, as we've always said, there's no simple or single solution to this. We're dealing with a legacy issue of over 200 years of development, and I guess a lot of what we're seeing out in the floodplain now is really a legacy of previous planning decisions. And particularly, I think, quite significant, I guess, the policy settings around 2006 and 7 had quite an influence on, I guess, what we're seeing today. So really, in terms of the mix, it's really when you're looking at flood risk management, you have to look at, what measures can you put in place to either mitigate or prevent, but for preparedness and response and recovery. And the strategy really comprises, the actions really are an integrated suite of complementary measures. I guess the important ones really here. So the dam is the really important for significantly reducing the existing risk. It's not about opening up more land for development. For managing ongoing growth, the land has already been rezoned. So to manage that, you really need to look at your planning framework, so planning policies, and that's regional land use planning framework, and roads. So we did look at roads as a potential alternative, but with roads, for major roads for upgrades, they do nothing to protect people's homes or businesses or the critical assets. They're critical for getting people out during an event, but that people may not have homes to come back to. So the dam is effective because it does both. So with the Hawkesbury Nepean, so with any new major upgrades for roads, they're required to look at flood resilience as part of that. It's much cheaper to do it as part of the planning process rather than to retrofit roads for flood resilience. The package that I just mentioned previously is the road resilient package. They're roads that already exist. They're not major roads, but they're feeder roads and affected by local local flooding. And they're critical to making sure that people can get onto the evacuation network. So it's about fixing up, low points, culverts, shoulders, some intersections and things like that, and some low bridges. So that's that package of, and then you need to have a community that's going to be able to be aware and respond. So a lot of our effort over the last 4 to 5 years is about building community resilience. It is a very diverse and complex community. It's dynamic. And evacuation science. So everything that we do is really a suite of complementary measures across that flood spectrum that I was talking about.
Yeah, the M4 upgrade, the Wet Northern Road upgrade, I'm very familiar with those, and I know there's been road upgrades over towards the Hawkesbury as well. So they're all complementary to this project.
Exactly, they're all complementary. And I think when we did look at major roads, I think major roads seems like a really good solution, but from our perspective, we're not looking at major roads for growth. We're actually looking at it from an evacuation perspective. So when you're looking at it from risk to life, because these are infrequent events but have catastrophic events, they don't stack up economically. So the most cost-effective way is when they are required for growth or for upgrades at that point in time, then you make sure that you incorporate the flood resilience.
So I think that's a reality check about what this is about. It's not just about, and as important it is to save lives and get people out of the flood zone, it's also about protecting property and business assets for economic and community recovery. The project has those two objectives?
Yeah,
absolutely. I guess life is paramount. That's our primary objective, but the second objective is really around to protect people's homes too, so reduce the impact of major flooding. We've always said you'd never be able to eliminate flooding in this valley, but we could significantly reduce it and give people a much better chance and recovery time to be much quicker.
I think it's worth saying that, when you see major natural disasters, the disaster itself and the events that happen during those days of the event. But unless there's a really strong recovery and resilience, those effects can last for years and destroy communities and families, and households break down. It's quite difficult.
Like fires and drought and so forth. It's just in that category. Right, that's the end of my questions, Mr. Chair. I don't know if Mr. Fang or I'm not sure if Taylor's there at the moment have questions.
I don't have any questions for the witnesses at the moment.
Then, Mr. Taylor?
None for me, thank you.
Ms. Sharp, I might just ask two quick ones, and then I'll throw to you if I could. My question relates to the changes, the ministerial reshuffle, and how that fits in the first instance. Now we see that Minister Stokes has moved into sort of an infrastructure role, and I'm just trying to understand his role in this project now, and whether or not Infrastructure New South Wales works to Minister Stokes in the first instance.
Yeah, now obviously, if we get too deep into ministerial reshuffle questions, then that's really a question for the Premier and others, not for us. But I can certainly say that the change that was made in December means that Minister Stokes, in our legislation, the Infrastructure New South Wales Act, Minister Stokes is now the responsible minister. So yes, we would provide advice to him on those matters. When it comes to the Hawkesbury Nepean flood strategy, there are other ministers involved: the Minister for Western Sydney, the Minister for Water, Minister for Planning, and others, Minister for Transport. So there are various portfolio responsibilities for different parts of that strategy because it's such a diverse strategy. But yes, it's quite correct, Chair, that Minister Stokes is the minister responsible under our Act.
It's pretty clear that quite a bit more work will need to be done on either the EIS or in preparing a preferred infrastructure report. Has additional money been sought? And given the new ministerial arrangements, what's the process for trying to get more money for this project now?
Yeah.
So Water New South Wales will be using their existing budget, so no further money will be sought for the additional work and for the preparation of the submissions or the PIR report.
Okay, so the money that's already been allocated under I think it originally came from the Climate Change Fund, is the extent of it. No further monies have been sought or will be required to finalise the EIS or preferred infrastructure report. Is that right?
Yeah, so that there's no climate change money. The climate change money's been expended, but the budget that's been allocated to Water New South Wales, there's no additional money being sought to do this work. They're operating within their current budgets.
No doubt, Chair, that with a budget process coming up and budget in June, if anyone has asked more money, this is the time they'll be asking for it, but we're not aware of any requests.
Okay, and you haven't asked for any more money for your aspects of this component of the floodplain management strategy? Okay. And just with regards to the business case, what's the status of the business case at this point? And can you just confirm your role and I guess the new infrastructure minister's role in the preparation of the business case?
Yeah, so a business case was prepared for consideration by government. It's under consideration by cabinet. My understanding is that that'll be further considered as the planning consent process advances.
So the business case has been finalised and submitted to cabinet for consideration.
Well,
Is that right?
as you can see from the EIS itself, all the work that was required to include in the EIS in relation to the benefit cost ratio, etc., was done, and that's really quite a significant element of the business case itself.
I'm not sure that answered the question. Has a business case been finalised at this point?
A business case has been prepared. As to finalise, that would be a matter for government whether they want to ask for more information. So there's a business case that has been provided to government, and they may ask for more information as the project advances.
Without wanting to get into matters of cabinet secrecy, can you confirm if that document says final business case on it? Is that the title of it?
It may say final business case, but it may say draft final business case. I can't recall. I'm sorry. Okay. But yes, you're right. We have to be quite careful not to get into stuff that's in front of cabinet.
I understand. Ms. Sharp, then I might hand over to you, but if we've got time, I may come back. Thank you.
Thank you. Just to follow up on that, in terms of the business case, was it submitted by yourselves or by Water New South Wales?
Yeah, well, I mean, sorry to be pedantic, but anything that goes to government gets submitted by a minister rather than by an agency.
Okay, well, which minister was it? Minister Stokes? Was it Minister Ayres? Was it now Minister? Is it Minister Anderson's now got water? Like who? Previous Minister Pavey? Who is the minister who submitted the business case?
Oh, so rather than going, because again we're talking about what's happening in cabinet, who's making submissions to cabinet, and which ministers, and that's something that we're not permitted to disclose.
Sure. I'm really not asking. I mean, you've said that there's been a business case prepared. I don't believe that this is any state secrets or breaching cabinet issues to understand, so that the public understands which minister has carriage of the business case.
Chair, I might just at this juncture remind the witness that they could take the question on notice if they are unsure of the position of the answer and perhaps seek advice and then provide it to us within 21 days.
Yeah, thanks. I will take it on notice, except to say that the ministerial responsibilities are as I've laid out earlier for the overall strategy.
Yeah, sorry, Mr. Draper. I mean, look, I like to think that I've got a pretty good understanding of the architecture of government, and I have looked very closely at the allocation of acts in relation to who's responsible for what. I still am unclear about which. So the proponent of the project is Water New South Wales, so that would be Minister Anderson. Is that correct?
He's the minister responsible for water. Yeah.
Yeah, so he's responsible for the actual project.
He's responsible for Water New South Wales, and Water New South Wales is the proponent for the dam wall raising.
And then the role that Infrastructure New South Wales is now under Minister Stokes. Is that correct?
Minister Ayres is still the coordinating minister.
Yeah, but just to answer your question, yes, Minister Stokes is the minister to whom we report under our legislation.
And the Hawkesbury flood mitigation part of that has been given to Minister Ayres. Is that correct?
He's the minister. The Minister for Western Sydney has carriage of the strategy. That's correct. And just maybe to expand in general terms, while we are responsible to Minister Stokes as the Minister for Infrastructure, and previously it was the Premier who was the Minister for Infrastructure, there are a number of ministers with whom we work with portfolio responsibilities, and whether that's on Hawkesbury and the Warragamba Dam, or it might be another project. So we do work with a number of ministers.
Yeah, no, sure, I'm across that, but obviously just for this one. So and just also to be clear then, so the Minister for Roads has got some interest in terms of the planning, and the Minister for Planning. What is well, I suppose that's the question. Is the final consent minister now then the Minister for Planning, i.e. Minister Roberts?
Yeah, I'll give you an answer, but I think it's probably worth asking those from Department of Planning who I think are appearing today. Certainly the Minister for Planning the Department of Planning and the Minister for Planning have the role as consent authority. There's also obviously federal legislation that has to be met as well, and there are arrangements between the Commonwealth and the state on that. But I think you'd be much better off asking for that question to.
Oh, don't worry, I will. Thank you. I will do that. It is a little confusing. My other question, though, is just to go back to the issue of legislation. Has there been legislation drafted, and have you had any involvement in that?
I can answer that. There's definitely no legislation that's been drafted, but, to my knowledge, because I guess we're not at that process. So, yeah, there would be no point in drafting any legislation at this point.
Right. Okay. So okay. All right. I might just leave it there for now, Chair.
Thank you, Ms. Sharp. Are there any other questions from other members, Mr. Searle?
From me, Mr. Chair.
Deputy Chair?
Nothing for me, thank you.
Government?
Sorry, I have one more if no one else has got one. Is that all right?
I'll just go around the room, Ms. Sharp. We'll just check in for I do, and I've got a couple more as well, but I'll come back to you first. Government?
I don't have any further questions, Chair. I'm not sure about my.
I wouldn't mind asking one more question. I'm not sure if it's directly relevant to these witnesses, but I was wondering about the if you'd like to comment on the proposal to manage water inundation, to manage flooding by permanently lowering the level of the dam. I know we've gone over it before, but now you've done the work on EIS and so forth. I thought it'd be worth revisiting that argument that if you drop the dam down, I guess equivalent to 17 metres. So you want to update us on this, on the thinking on that?
Yeah, so I'll just start that you couldn't drop it the equivalent of 17 metres. I think the option there's two options that are analysed. One is to drop it by 5 metres, and the other is to drop it by 12 metres, and there's technical reasons why you can't do it further, but probably the most overwhelming reason why, there's two reasons why those options are not favoured and don't perform. One is they don't deliver the flood mitigation benefits that a dam wall raising does. So unfortunately, in very significant floods, they just wouldn't hold back enough flood waters. But the second is that, of course, they precipitate a significant decline in water supply for Sydney, and so that generates either some very major costs to the population or costs in terms of developing replacement water security facilities. So
you're talking desalination.
Desalination, yeah.
How many plants would be required?
Well,
I think at least 2. I think would be the answer.
2 additional plants.
That's my understanding. Again, it's better off asking Water New South Wales.
Okay.
Well, probably Department of Water.
Sorry,
DPE Water.
Yeah.
So we work very closely with DPE Water, who were responsible for developing the Greater Sydney Water Strategy. So, all the information that was presented in the EIS was done in conjunct with them as part of the development of the water strategy, and there was consultation, I think, at a similar time when we were out on EIS. I guess the key point, one of the back in 2017 when we released the strategy, the -5 option performed better because at that time there was a bigger gap, but at our current time, Sydney's at its sustainable water limit. So any sort of reduction in water supply, water security, and Warragamba supplies 80% of Sydney's water storage. It's I think it's the largest urban water dam in the Southern Hemisphere. So any reduction in water supply would have a significant impact on water security. So the Greater Sydney Water Strategy, I guess they put forward a lot of measures in terms of trying to meet ongoing for future growth, but also for drought security. So if we're going to drop water supply for as an alternative for flood mitigation, -5 it doesn't really do much at all. It only was going to mitigate for very small events. -12 will provide modest benefits, but it certainly comes at a significant cost. and you'd need to replace the water that's lost or foregone from reducing the water supply, and you'd need to have that in place before you could start a flood mitigation function. So you need to build desal plants for that before you could even contemplate the drought and the current demands of the population of around 5 million people.
And a desal plant, or two more desal plants, had a whole lot of environmental impacts. Again,
they have their own impacts and greenhouse. Yeah. So look, everything you do has its impacts. So there's nothing that comes here that's going to be free of impact. And the desalination plants are more expensive. That's why I guess if you look at the BCRs for the drop in water supply, they are much lower than the raising the dam. And I think we've also said, if you remember the V-shaped valley, so you don't get as many benefits by going down. So by raising the dam, the spillways up to 14 metres gives you the greatest benefits.
Okay, thank you. That's end of my question line there, Mr. Chair.
Thank you, Mr. Mallard. Ms. Sharp, before I hand to you, I might just do a follow-up on that one. Ms. Voodoo, obviously we've seen some of the original documentations in the BCRs for the various options, but of course this project is now far more advanced. We're aware of significant cost blowouts, and the EIS unfortunately is incomplete when it comes to some of the full costs, especially around biodiversity offsets. How is the public to make a judgment about the cost benefit of the various options without this information being transparent? I assume that information in more detail about the various options and the costs would be fully contained in the business case that's been submitted to government. Is that true?
So I guess the first point I'd make probably is that, I guess normal EISs, you don't normally put, it's not normally a cost benefit analysis. We've tried to put as much information as we can, particularly just from a relative comparison of the different options to see how they would perform. So the level of information that we've provided there was to provide some of that comparative, I guess, from a performance point of view. Of course, the details, the government is as part of the work that we do for cost benefit and providing that advice to government, it's far more detailed, and it is very detailed work. And certainly there has been a provision, and I think you raised this question last time, but certainly around the biodiversity offsets, a provision was provided in the net present value, which is the standard economic tool to compare the different options.
But the actual full cost of that is not articulated in dollar terms. Biodiversity offset costs are not articulated in dollar terms, nor are the actual offsets and where they might be obtained identified in the report.
Yeah, and I think that's the reason for that is because that's in a way part of the product of the EIS itself, and I think that's what the Energy and Science group have pointed out in their submission, that some of this has to be worked out by the proponent as part of the EIS process itself.
I think Water New South Wales will give you more details on that this afternoon, but certainly in Chapter 13, they certainly identify the credits. So the credits, I guess, are basically the basis of how you retire those credits will depend on what the final value is. But certainly there was a value that was provided as provisional value. So in terms of, I think it was Chapter 13 outlines, and I think Water New South Wales this afternoon might be able to provide a bit more detail around their proposed strategy.
Here again, I don't want to belabor the point, but we get into this ridiculous circular argument where we're sort of waiting for the outcome of the planning process to be able to work out what the project looks like, but you've already submitted a business case to government, and it's hard to understand on what basis you've submitted that business case, what level of detail you've included in there, what assumptions you've made about what ultimately might be approved through the planning system. Wouldn't it just be easier if all of this information was transparent? Why would the business case not be made public?
Well, I think the point that Ms. Abood was making a moment ago is the EIS itself is much more transparent than usual. There's more information in that than the public would normally get, and we thought that was a good thing to do. We've been very, in that process, very transparent about the costs of the dam, the fact that it's changed from the initial preliminary estimate back in 2015. I think there's a fair bit of detail there, and I think the public would appreciate that we've been provided a lot more than they would normally get for a project like this.
Okay, I've just got one more. There was some commentary recently from a member of Floodplain Management Australia on the dam. Have you had any engagement with Floodplain Management Australia, either Infrastructure New South Wales as an entity, or either yourself, Mr. Draper, or yourself, Mr. Booth?
I don't believe I have had any, no.
So the floodplain, they're I guess a professional body which various members would be members of, but my engagement has been I guess sometimes we participate just as presentations, but I haven't done any of that for quite some years. We did receive an FMA award for best project for community resilience. So we got the NRMA award last year for best project or best program of the year for building community resilience for flood. That's at the level of our engagement.
So that is an award that was issued through Floodplain Management Australia, was it?
Yeah.
Yeah. Okay. But you don't recall having a conversation with any individuals from there or correspondence with them about this project specifically in the last 6 months?
I said as my interaction with FMA has been mainly around the project, and we were awarded a prize, which so.
When you say the project,
the program, the community resilience program that for preparedness of communities. So we were awarded a prize. We negotiated with the FMA to be able to donate that to a worthy recipient in one of the community groups that would help them with flood preparedness for, I think it was for homeless people. So that's been my level of engagement with the FMA.
Okay, and just one quick final one on this new change again of ministerial responsibilities. Do you brief Minister Ayres directly on the floodplain management program, or do you now do that through Minister Stokes?
Well, obviously these changes are fairly recent, but we generally brief both ministers because Minister Stokes, as Ms. Sharp was pointing out earlier, is our minister. Oh, sorry, it might have been Mr. Phil. So was pointing out that is our minister under our legislation, and so we certainly brief Minister Stokes, and we brief Minister Ayres as the portfolio minister for that program.
Do you brief them separately or together?
Well, it would vary from time to time.
When was the last time you briefed Minister Ayres?
Well, if
you take it on notice.
Yeah, I'll take it on notice because I can't remember. I'm sorry.
That's all right. Thank you. No, that's fine. Ms. Sharp.
Thank you. Two more hopefully quick ones from me. What is the in terms of the cost for the project, there's obviously some costs outlined in the EIS, but you've said that you've done the business case. Can you give us an update on the anticipated estimated cost of the project?
They're still as they set out in the EIS.
So that it hasn't changed with the business case? Thank you. And what is the role of Infrastructure New South Wales in the preferred infrastructure report process?
I don't know that we have a role at all. I might have to take that on notice, Ms. Sharp, and come back to you, but I'm not sure that we have a role at all in that.
Given that I'm very confused really about what your role is, given you sort of seem to coordinate everything, but then you're not the proponent. So given the concerns of all of the different agencies, you've got no role in trying to bring that together. Given Minister Ayres's extreme enthusiasm for the project, and you're reporting to him on this project, you have no role?
No, we didn't say that, but you're asking about a very specific document, and that's a sort of a kind of a statutory process.
Sure.
Planning. But if I can draw an analogy, there's lots of elements of this project in which we don't get that very involved because there are other agencies with much more active portfolio responsibilities. Similarly, when it comes to investigating road requirements and those sorts of things, there are other agencies better suited to do that.
So we're supporting New South Wales with the information they need, particularly for the submissions report, as I said, around the options assessment and things that are the strategic context components of it. But Water New South Wales, being the proponent, will be responsible for the PIR. I'm still struggling to understand the need for the PIR, but certainly the submissions report, we will support them with the information where we have some sort of responsibility.
So you will feed into that, but it's direct. I mean, look, I'm not trying to be tricky about this. I am genuinely just trying to work out who's responsible for what. So in terms of the kind of the flood, yeah, dealing with the submissions. So so there is a role in terms of coordinating the other agencies.
Well, it's the information that, as I said, the strategic context. So anything that I guess has been raised in issue to, whether it be around the roads or around the options assessment or any of those sorts of things, we will certainly deal with those. And but I guess Water New South Wales as a proponent would deal with the matters strictly around the EIS, and I guess they are still responsible for developing the PIR, but we will be working with them to support them to provide the information and help them, I guess, any information they need from the agencies. And it's your view, Ms. Abood, that a preferred infrastructure report, PIR, is not required? I'm not saying that. I didn't say it wasn't, but I was trying to understand the need for it. That's all. I'm trying to clarify the purpose of why it's required.
That's a matter. We'll leave that to the planning people to figure out.
Yeah, don't worry. We'll come back to them. Thank you very much.
Thank you, Michelle. Just very quick, anyone that wants to ask a question, this is the last opportunity before we move on. Speak now. No, thank you. Then I think the witnesses for your appearance here today, and I believe there might have been one or two questions that were taken on notice. The committee has resolved that answers to those questions be returned within 21 days, and the Secretariat will contact you in relation to those questions that were taken on notice. Thank you very much. I think the committee is now having a short break, and we'll return at 11:15.
Thank you very much.
I'll welcome our next witnesses to today's hearing. Mr. Kidman, Mr. Smith and Mr. Knudsen, I'll get you to start by stating your name, position, title, and swear either an oath or affirmation. Mr. Fleming, sorry, you will be examined on your former oath to this committee. Can I start with you, Mr. Kidman, please?
Yes, of course. My name is Samuel Kidman. I'm the Executive Director of Heritage New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
You can hear me. I seem to be having trouble with my connection, or perhaps it's the witness.
Could you hear me before? Okay, cool.
I can hear it very clearly. I think it's Justin now that.
Justin's now, I couldn't hear it before.
Would you like me to affirm again, Mr. Field?
I think I just lost everyone momentarily. Perhaps to the Secretariat firstly, can you hear me? See me? Yes. Okay. Sorry, Mr. Kidman. If you could, we'll start again. Thank you.
No problem. My name is Samuel Kidman. I'm the Executive Director of Heritage New South Wales. I solemnly, sincerely affirm that the evidence I give today should be the truth, the whole truth, and nothing but the truth.
Thank you. Mr. Smith.
Thank you. Timothy Smith, Director of Assessments at Heritage New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. Thank you.
Thank you. And Mr. Knudsen, please.
Thank you. Dean Knudsen, Deputy Secretary, Biodiversity, Conservation and Science. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Okay, thank you. I might open with questions if I could. Oh, actually, no, sorry, I might just check. Is there any witness that'd like to make a short opening statement to the committee? No? Okay, then I'll start with some questions from myself before I pass on to other members. Obviously, we've seen some of the agency submissions to the EIS. I guess I'd start with you, possibly, Mr. Kidman. Do you think it is a fair way to describe your submission and position of your agency that the EIS does not adequately assess the natural and cultural values to the Greater Blue Mountains World Heritage Area?
Well, I think that's pretty clear from our submission, Mr. Field. I suppose what the submission goes into some detail about is where we think that the environmental impact statement could be improved to take greater account, in particular, of Aboriginal cultural heritage values. And I think the extent of the survey area, but I think all of those details are fairly clearly articulated in our submission.
So we understand now that from evidence that we've heard this morning that there won't be any additional financial resources allocated to work on the EIS. And the suggestion is that there's going to be a preferred infrastructure report process gone through to address any of the inadequacies. So I guess my question to you is, what additional work do you think would be necessary to update the EIS to address your concerns?
Well, there are a number of things, and again, they're pretty. I mean, our role, of course, is to provide advice to DPE in relation to the potential impact to heritage values, and we rely on the information in the EIS to make an appropriate assessment. I suppose we have provided this advice to DPE on the 17th of December. We had some concerns with the Aboriginal Cultural Heritage Assessment Report and the supporting documentation. There is, and this is also clearly articulated in the submission, I think, is that the implications of the impacts to Aboriginal cultural heritage are understated. And also, as the submission makes clear, that the based on the assessment and the investigation area, it's hard for us at this stage to understand the breadth and the scope of the impacts, and so we've gone back to DPE, New South Wales, requesting some further work be done.
Would that require additional field work to be done?
Well, look, I don't know. I mean, I assume it would, but I'm not in charge of the funding of that project or the assessment. We provide comment on the documents that are provided to us.
I understand. I'm not trying to put you in a difficult position,
No.
Kidman, but we're getting certainly very limited information from certainly Infrastructure New South Wales, and we'll try this afternoon, I'm sure, with planning and the proponent, but just trying to understand the extent of additional work that would need to be done so we can make those questions as useful as possible.
Sure. Well, I suppose what I might say is that, I mean, as our submission makes clear, there are a couple of key factors, I suppose. One is the extent, the size of the investigation area, and using that to extrapolate over a much broader area. And I think, as our submission makes clear, the consultation with the Aboriginal community and registered Aboriginal parties could be perhaps improved. And whether that means additional resourcing, I honestly don't know.
Okay, fair enough. Then I might direct a similar question to EES, and Mr. Newton, is probably for you. With regards to the World Heritage elements of the assessment, I guess, am I again fair to say, and I know your agencies have made submissions to the EIS process I'm not asking you to go over the full extent, but I guess the committee needs to hear this evidence directly as well for us to be able to incorporate it into our report. So is it fair to say that the EIS does not adequately address the World Heritage impacts of this proposal?
Chair, I believe that is absolutely the case. And indeed, our submission pretty much used exactly those words. We listed off about 6 different areas that we thought needed additional work. And that could be, to pick up Mr. Kidman's point, the proponent may have already done that work, but it wasn't reflected in the documentation shared with us. So on World Heritage, there's a number of issues that we think need to be addressed. And certainly the Aboriginal cultural heritage point that Mr. Kidman already raised is definitely one of those. But there's also deficiencies with respect to the impacts on biodiversity as it relates to why the property was listed as a World Heritage property.
Now, and thank you for that. I guess I've got a couple, but just to step through that logical line of questioning that I did before as well, what additional work do you think would need to be done to address those concerns?
Well, the key issues are to take a look at the statement of outstanding universal value for the property, and make sure that that is comprehensively assessed. Whatever is included in that statement, that includes a listing of all the criteria for which the property was listed under the World Heritage Convention. Those need to be looked at in great detail. And then finally, there's a catch-all phrase which I think the proponent has struggled with, which is about the integrity of the values. And that's where, in particular, the Aboriginal cultural heritage element comes out. But like I said, on biodiversity, as well as it relates to the World Heritage values, we think there are some truly unique, globally significant biodiversity aspects to the World Heritage property that need to be more adequately addressed, and that was the nature of our submission on the EIS.
Do you think that would require additional field work, or what? Or are you not able to make a judgment on that based on the information that was in the EIS?
It's the latter, Chair. We don't know what the proponent necessarily has in terms of the full extent of detail. All we could comment on was what we received.
So there was a series of leaks of agency submissions or agency comments on the draft EIS. I think we're talking now, well over 12 months ago. Some of the witnesses here today may have been at the hearing where we looked at that. Now, our understanding was that there was then quite significant interactions between the agencies and planning and the proponent to sort of go through those adequacy concerns and to address them. It seems though that largely they haven't been addressed in the final EIS. So I guess my question to you in the first case, Mr. Knudsen, can you explain what was that engagement between planning, your agency, and the proponent between those draft comments and the final submission of the EIS?
Chair, I can't really give you an awful lot of detail because I joined the department after those events and that last testimony, but certainly we can come back and detail the extent of meetings that happened and what was discussed at a fairly high level between ourselves and planning in particular. Planning's the main interlocutor with the proponent. We don't deal directly with a proponent. That's fairly standard, but we can walk through what we provided to planning in terms of our comments back to Water New South Wales, and make sure that you've got all the information that we have. We're happy to provide that on notice.
Okay, thank you. I appreciate that. Mr. Fleming, of course, I do recall that you were at that hearing in particular, and we did ask you a number of questions about the concerns that you raised in your initial comments on the draft EIS. Can you make comment on how you feel they've been addressed in the final EIS, or if at all?
I think I'd have to echo what Mr. Knudsen has said, in that there are still some elements that require additional work. And they are articulated in a fair bit of detail through the submission, including in the sort of National Parks and Wildlife Service component of the submission. So I'm not sure I can add to them. I don't have anything to add out that is not in our submission, if that's the question. But
well, I guess my question is, what do you think a reasonable effort has been made to address the concerns that you initially raised, or has it just been fobbed off by planning or the proponent?
The one thing I'd say, Chair, is that my staff have told me that a number of the comments that we provided were reflected in the updated documentation by the opponent, but not comprehensively, and that's why we've got such an extensive list of issues that we provided in our submission that we still believe need to be detailed. But in terms of the specifics, I don't think Mr. Fleming or myself would have that level of detail for you, but I can give you that assurance that some was definitely taken on board, but there is more to be done, no question.
I think, Mr. Field, I would say it's a complex project. It's a really complex project to assess. I think if you're asking me if it's being done in good faith, I think the answer is yes, it's being done in good faith. If your question is, are there issues that are still outstanding? I think the answer is yes, there are issues that are still outstanding. You're specifically asking me, I think, about a couple of the concerns I raised in the early stages of this, and one of those was the impact of the bushfires and whether areas post the fires had effectively attained a greater significance as refuge for species. And I think you'll see from the submission that EES put in that's an area that still needs a little bit more analysis. So, there are issues, they're complex, they're difficult. I think they're being addressed in good faith. But there are still some outstanding matters that need to be addressed to ensure it's rigorously assessed.
I see your hand, Mr. Searle. I will just ask one more on that, and if I get a chance, I'll come back. It seemed that questions that were initially raised by this committee and other members of the public about addressing those bushfire risks were largely, the comment was it was difficult to get in and do that analysis because of the impact of the burn and the risks. I would assume your understanding of the terrain out there and the recovery is that there would be no barrier now to getting out in the field and doing that level of assessment at the moment.
I can only comment to say that as a result of floods, there have been some barriers to entry and sort of movement around the site over the last sort of 12 months, and you can imagine that to be the case. But in terms of any more detail on that, I'm afraid I'm not in a position to add the detail.
Okay. Yes, go ahead, Mr. Kidman, and I think you wanted to make comment on this, and I'm happy for you, Mr. Knudsen, as well.
Sorry, Mr. Field. Yeah, look, I would just make a couple of points in relation to some recommendations that this committee raised in its interim report. There were a couple of recommendations which were picked up by Water New South Wales. One was about you recommended a standalone anthropological report to address identification and assessment of cultural values and how they relate to archaeology and landscape and the impact of the proposal. So I can confirm that Water New South Wales did provide that as Appendix K to the EIS. You also requested further archaeological assessment of potential archaeological deposits. That was provided by Water New South Wales. And the development of a cultural heritage management plan prior to submission. And based on the documentation that was made public last year, that plan will be provided pre-construction in consultation with registered Aboriginal parties in the Aboriginal community. So I just wanted to make those points.
Thank you for that update, Mr. Kidman. Mr. Knudsen, did you have something to add before I hand to Mr. Searle?
Just a very quick one, Chair, which is that we acknowledge in our submission that the sixth assessment report of the International Panel on Climate Change was not available at the time that the EIS was prepared, but that goes to the essence of your question in terms of what's happening with respect to global climate change predictions and impacts, which could now be taken into account more than they could have when the EIS was done originally. So I just wanted to flag that.
Okay, thank you. Mr. Searle, you had indicated you had some questions, I think.
Yes, I just wanted to ask Mr. Fleming, what are the key outstanding issues from the perspective of the organisation he represents.
So in a moment, I'll ask Mr. Knudsen to add a list of a few items on the biodiversity side. I'll concentrate on the national park side, and they are fully articulated in the submission. So my apologies, I might miss a few, but yes, articulating a little better the impact of the proposal on World Heritage values, and that includes on the integrity of those values is something that needs a bit more work. There are aspects of the national park that haven't been fully assessed. So some of the historic heritage sites, some of the impacts of the project on infrastructure and on our capacity to manage the national park adequately. Obviously, the cultural heritage, which is an important part of both the national park and the World Heritage, or the integrity of the World Heritage area, and Mr. Kidman's outlined in the submission from Heritage New South Wales the key issues there. And then there are a series of, and I apologise if I'm missing any, but there are then a series of biodiversity issues which really straddle both national parks and the broader EES biodiversity remit. And I will just say that extends from both threatened species through to also endemic species, and some other important restricted range species, and then other species that are, if you like, again, tied into the World Heritage listing, remembering that one of the key outstanding values of the property is the fact that it's a centre for the diversity and evolution of eucalypt species. So I run through that list in part because not all of those biodiversity impacts will be picked up in, for example, the offsets analysis. So what needs to be assessed is a little broader than what might be assessed purely from an offsets point of view. Mr. Knudsen.
Great, thank you, Mr. Fleming. So you've already mentioned the World Heritage elements, and we've canvassed that a fair amount already. The offsets arrangements are something that does need to be addressed pretty extensively as we go forward. That'll include the downstream impacts as well. On biodiversity, we had almost a first principles kind of issue on that with respect to the polygons of the design of the actual project, and therefore its impacts are yet to be settled. That will allow us to then proceed and finalize that assessment of biodiversity impacts. The climate risk, we talked a little bit about it in the previous question, but I would also note that New South Wales has its net zero plan, which could be more fulsomely addressed. Floodplain risk management is another piece that we flag that we think needs to be looked at. And then the last of the areas that we mentioned is about hydrological and aquatic ecology, noting that there's about 284 kilometers of upstream waterways that'll be potentially inundated through the project's impacts, and that needs to be assessed more fulsomely as well. But those are the broad 6 categories.
I would just add, in case I didn't cover it properly, the impact on infrastructure and our ability to do things like feral animal control and fire management is another matter that needs just a little bit more attention.
You're on mute, Mr. Searle.
Thank you, Mr. Chair. Mr. Fleming, can you just flesh that last point out? Like, what are the additional concerns you have in relation to infrastructure and feral animal control?
There are a number of bridges and culverts. I can't remember the exact number, but it's sort of over 20 distributed through the study area, I think it is. And so we need to get a good sense of what the implementation of the project will do to our ability to get around and deliver effective management.
Thank you, Mr. Chair. That was my question.
Good, thank you. Ms. Sharp, you want to continue for the opposition? Go ahead.
I do. Thank you, Chair, and thanks for everyone coming in today. Just a first question, Mr. Knudsen. I think that you said that you're now biodiversity, conservation and science. Does that mean that EES doesn't exist anymore in terms of the configuration within the department?
No, it absolutely does continue to exist. And Mr. Fleming is the acting coordinator general for EES.
Okay, I'll need to get an org chart. I think that's very confusing to me. And heritage is back in the cluster, yes?
Heritage will be back in the cluster as a part of EES from the 1st of April.
Yeah, thank you. Thank you, Mr. Gibbon. I wanted to just ask, we heard this morning that the business case has been submitted to Cabinet and is under consideration. Did any of your agencies have an input into the business case?
Not that I'm aware of, but we'll come back on notice and absolutely confirm that for you.
No, not that I'm aware of either, but I can check that.
Thank you. And the reason that I'm asking about the business case, which obviously is that we were also told that there's no change in relation to the cost profile or the estimated costs of the project as it stands. Can I just clarify? Then there's been significant concerns about whether the way that the biodiversity offsets will be accounted for is whether they're a temporary inundation or whether there's permanent damage. Is that something that you believe still needs to be resolved, or is that something that you have accepted now is within the EIS that it's temporary inundation, and understanding there'll have to be calculations later, but that the issue around temporary versus permanent is agreed to? I'm not sure who to ask. I'm not sure whether it's you, Mr. Knudsen, or Mr. Fleming.
I believe it's me, and the answer is that you're exactly right that at the back end of the process, once the final preferred infrastructure plan comes in, along with the response to all the submissions that the proponent has received, they'll come forward with their final proposition with respect to the project. That'll allow us then to take a look at the required offsets, but ultimately that's then a decision for planning as to the adequacy of those. We'll provide our input, but there's a number of steps that still need to happen. That being said, I think you were also getting at this issue of temporary and permanent inundation. What my staff have told me is that there was an agreement in effect to take a look at historical models of inundation using Monte Carlo predictions over a 200,000 year period, or quite a long, extensive period of time, to come up with what's the likely maximum inundation during a 20-year estimate. That's what's been used to form the foundation of figuring out what the inundation impacts look like, and therefore what the initial calculations with respect to offsets are. That being said, it's quite technical, and I'm very happy if it is helpful to the committee to come back and explain what we've come up with as a group of agencies as the approach to managing or predicting the possible inundation areas. And certainly we can provide detail on that to you if that would be helpful.
I'd welcome that, but obviously the crux of all of this in terms of the costings for this project is whether it's considered temporary or permanent, and the required offsets as a result of that. Can I just clarify that the position of EES remains that it should be considered permanent, and that temporary, is that correct, or am I wrong about that?
So my understanding, and again, at the risk of, I don't want to mislead the committee, but my understanding is that we've done that analysis to figure out what the likely maximum impact in an average 20-year period would look like, and base the proposed offsets on that, on the basis of that. So it's not necessarily tied to whether it's permanent or temporary, but what's the expected impact associated with a average 20-year period. So what I would suggest is that I come back with the specifics on here's how that 20-year estimate, just to use shorthand, was derived, and here's how it then has led to a calculation of offsets. I know that there's also downstream versus upstream impacts that we're trying to take a look at. There's real complexity if you think about if there's any attempt to try and do offsets with respect to Aboriginal cultural heritage, etc.
Well, you can't offset. You can't offset a filled one of the song lines in terms of those pools.
That's right.
And similarly, given the numbers with Regent honeyeaters, if their habitat is killed, basically unable to survive, then it's a pretty permanent impact, even if the inundation might only be temporary. But look, we've had this argument before. I'm not trying to draw you on. I'm just trying to understand how it's actually going to be resolved.
Yeah.
Mr. Fleming, you had your hand.
I just wanted to add, I think it's a question that you should direct to planning, because planning is the agency that ultimately determines the offsets. But to add to what Mr. Knudsen is saying, our understanding of the way in which this assessment is unfolding is that a line has been drawn, which Mr. Knudsen has described as essentially, for want of a better term, the 20-year event line. That's 1,400 hectares, and there's an assumption that there is within that area, if you like, complete loss of biodiversity. And that's the basis for the offsets. Now, please do confirm that with planning, because they are the entity that's responsible for it. The impacts are being assessed wherever they occur, but the basis for the offsets, I think, is around that 20-year period, and assuming complete loss of biodiversity there, which is arguably a greater loss than will occur within that area, but on the other hand, it's not taking into account some of the impacts outside of that area.
Ms. Sharp, could I just ask a follow-up on that one?
Yes,
Sorry
yes.
to jump in.
No, that's fine.
If I understood you correctly, this 20-year average for offset determination was agreed by your agency. Is that correct?
My understanding is that the government agencies involved in this assessment did agree, yes, that would be the basis for proceeding. I'm using it the 20-year term quite colloquially because Dean Knudsen did a great job of trying to explain it. I didn't fully understand it, but it's complex. But it's around 1,400 hectares in total, of which a bit over 1,300 hectares is national park.
Which EES has sort of signed on to that approach.
That's correct.
Correct.
Yeah. And do you think that is consistent with the biodiversity assessment methodology?
It isn't, and it doesn't need to be, because this is being assessed under the former legislation and the former framework.
Okay, thank you. Ms. Sharp, all yours.
Thank you. I think this really is to Mr. Kidman. I mean, the crux, there's three issues as I see it in terms of the Aboriginal cultural heritage difficulties with this project. One is that we can call for more consultation with the traditional owners, but they've been pretty clear that they don't support the project. So I'm not quite sure how that issue gets further resolved. But look, the second issue is that this is whether there's temporary inundation and around biodiversity offsets and those kind of things. What the traditional owners tell us is that essentially this will be permanently, basically permanently damaged, and they can't be offset. And look, the third issue is obviously, and Mr. Field touched on this before, was the quality of the assessment in the first place, which I think there's been general agreement there's real problems with. I mean, how, in terms of Heritage New South Wales, I mean, you've given your advice now. How do those issues get squared off from your behalf? I mean, do you get what is your role from now on in terms of providing advice, or is that it?
No. Well, I don't think that will be the end of our role. I mean, we're of course not the approval authority. We have no regulatory authority in this space.
No. I know all of that, but we come to you for the advice, and you've given advice. So
absolutely.
I want to know how they get squared away.
No. My understanding is the next stage in the process will be for the proponent to review our submission on the EIS and come back to us with a response as to how they will amend the EIS documentation to make it more adequate. In relation to your comment about offsets, you're quite right. And we made that point quite strongly in our submission, is that of course the cultural values, whether they be tangible, rock art, grinding grooves, or intangible values such as songlines, stories. They are unique to that part of the valley, and they can't be offset in any other part of New South Wales. So you're correct in relation to that. Was there another question? I'm sorry, Ms. Sharp.
Yeah, sorry. I'll just to follow up with that. So far, how many times have you met with Water New South Wales in relation to these matters?
Look, I'd have to take that on notice.
It's all right. You take that on notice. I don't expect you to know off the top of your head.
But what I can say is that there has been a very considerable amount of consultation with Water New South Wales over the last few years. I came into this job in July last year, but my understanding is that the relationship goes back much further in relation to this project. Yeah, but I'll take that on notice.
Thank you. Yep, Mr. Fleming. I was coming to you in a minute, but you can jump in there too.
I just wanted to come back to the fact that planning really are the agency running this process. So we've given advice, as Mr. Kidman's articulated. The next steps from here, it really is a matter for planning as to what they need to complete their assessment of the project. And we assume that they seek further additional information from the proponent. They may seek additional information from us as part of that, but ultimately I think planning of the agency, you need to ask about where to from here.
That's great. I've just got it's a National Parks and Wildlife question, which is to you, Mr. Fleming, but I hadn't realised that you are now the Acting Coordinator General, so I think you'll still be able to answer this. I'm just trying to understand what how much consultation National Parks and Wildlife Services had with the Blue Mountains World Heritage Advisory Committee.
I wouldn't be able to tell you off the top of my head the level of engagement. You're talking about our local advisory committee.
Yeah.
I understand they've made a submission to the EIS. That information has come to me via the National Parks staff, so I can only assume that there's been some level of engagement, as I assume there's ongoing engagement really with that committee.
Thank you, and yeah, very happy for you to come back to us about that. Given that, and this again follows on a little bit from what Mr. Field was asking previously, field work. Do you think there's going to be a need for more field work in relation to fire and flood impact that's occurred since,
I think we've identified the issues that need further consideration. Again, it's really up to planning and the proponent to determine whether they need to do field work in order to adequately address the issues that we've raised. I think if you go through our submission, there probably are a few instances where it is suggested either by Mr. Knudson's team in biodiversity or by the parks component of the submission where some additional field work may be needed. I stand to be corrected if I'm wrong about that, but I think it's flagged in a couple of instances in the submission. But ultimately, it's a question for planning and the proponent to, address adequately the concerns that are raised and to determine if they need to do field work in order to do that.
I've got one more question at this part, which is for you, Mr. Knudsen, which is, has there been any preliminary discussion with the federal government in relation to this project, and in particular the Commonwealth Environment Department?
Yeah, so because this is being assessed under an assessment bilateral agreement with the Commonwealth, there would have been, going back several years, there would be a considerable engagement with the Commonwealth Department, because as you know, that's one assessment that serves for the decisions by both levels of government. That being said, it's planning as main interlocutor with the Commonwealth Environment Department on this, but it's an absolute given that there will have been engagement with the Commonwealth on a project of this magnitude and significance.
And how does that, sorry, and that's okay, thank you for that, that's actually helpful. How does that work given the role that EES has under the EPBC Act in terms of assessments and advice with impact on World Heritage values? So I mean, you're saying planning is the kind of main go-to. Where does your agency fit within that?
So if you think about it, Ms. Sharp, that we're providing our advice to planning on issues related to World Heritage, threatened species, etc. Planning then compiles that along with the various other aspects that they're pulling together. They then share that with their Commonwealth counterparts who do pretty much the same thing. That's the area I used to oversight in the Commonwealth. So you have the assessments team, which is equivalent to planning, and then they have their expertise on threatened species, on heritage, et cetera, that then support them to make their decisions. So it's the exact same model in parallel. I hope that's helpful.
I don't think I understand that, but that's okay. I'll ask another question, and maybe I'll understand it better.
Sure.
I had understood that so from your previous comment, you'd said, well, it's basically a joint assessment project with the two, and so there would have been discussions, which I understand all of that. But I had thought that under EPBC that EES actually is an accredited assessor. Are you now saying that the assessment would actually be happening at the Commonwealth level, not through you guys, because as a result of the way this project is configured in New South Wales, that planning is the assessor?
Sorry,
I might be completely misunderstanding this.
I think I have made this more confusing than it needs to be. You have planning, and you have the equivalent in the Commonwealth. Those two, which is the environmental assessment and approvals area, they pull together their expertise within their organizations on threatened species, heritage, et cetera. That's where we fit in. We're the advisors who provide that expertise, along with SAM on heritage issues. For example, Commonwealth has the exact same sort of thing. What ends up happening, though, in reality is under assessment bilateral agreements, the state, 9 times out of 10 at least, will take the lead, do most of the work with the proponent, come back to the Commonwealth. The Commonwealth then takes a look at the state assessment, decides whether it is adequate, decides whether they want to add additional conditions or make a different decision than the state has made, and that's the way it works through. So basically the Commonwealth relies on the state to get it to very close to finish, and then they do effectively a check against their legislative responsibility before making their decision.
I understand that better now. So that essentially also means then again, and I think you've said this all in various different ways today, is that so heritage and yourselves and national parks will basically work through planning, and then planning will go to the Commonwealth, and the Commonwealth will do the sort of the final check under the EPBC. Is that correct?
That's correct.
Thank you. Sorry, that was.
That's fine.
It's
a complex system.
Quite complicated. That's it from me for the moment, Chair.
Just one quick follow-up from me, and then I'll hand to the government. So you won't, Mr. Knudsen, have any interaction with the Commonwealth at that point. That will be between the Commonwealth and the New South Wales Planning Department. And would you have knowledge of whether or not those discussions are already happening, or whether or not it will only get referred to the Commonwealth once sort of a consideration of the once they've finished the assessment report?
So the normal practice from my past life would be there are regular discussions that happen, say, every couple months. They go through, both jurisdictions sit down, go through all the projects they're assessing, what are the key issues, how are they being resolved, et cetera. That's just almost a health check, and they'll share different chapters and things like that as you're working your way through, because we're all very conscious about the timeframes associated with legislative decisions, et cetera. But to the specifics of this project, I think your question is best referred to planning to find out how they gone with respect to their engagement with the Commonwealth, what are the proposed next steps, et cetera. There's also a scenario where the Commonwealth receives a project that they feel is fully assessed, the conditions are more than adequate, et cetera, and they literally will make a decision that says, do what the state said. So it really can run a very large gamut of outcomes.
Okay. We'll certainly get into that this afternoon with planning. Can I throw to government members now? Are there any questions from government for these?
May I add a couple of comments, Mr. Field?
You may.
I just wanted to go back to the question from Mr. Searle and add an additional example. One of the other factors that needs to be considered in more detail is the impacts of sedimentation post-flooding, and in particular, the risk for weed invasion by weeds. So that's the sort of thing that under the national park heading needs a bit more. And Ms. Sharp, I'm told that there's been significant engagement with the advisory committee, and that has included, I think they get regular briefings or have had quite regular briefings from Water in New South Wales.
Thank you, Mr. Fleming. Mr. Mallard, have you got any questions for these witnesses?
I do, thank you, Mr. Chair, and I see Taylor's there, so defer to him in a minute as well. Mr. Fleming, that was a good segue to my line of questions. We had the delight to trek into the catchment probably 2 years ago now, so during the drought, I think. And you just talked about sedimentation and weed infestation, but what I saw in the margin where we went, and I think it's called Soldier's Point from memory, was a lot of sedimentation, a lot of feral pig damage, wild horses damage, and a lot of weeds. Have you assessed seriously the quality of the margin that's impacted by this proposed inundation for flood mitigation? Have you guys done that assessment of the quality of that margin?
We haven't done that assessment. I think the question is whether the EIS has assessed any change in quality that might effectively be an impact of the project. So it's up to the proponent and planning, if you like, to ensure that that assessment is done. No,
but when you cite a percentage of the national park could be inundated, you must have done an assessment of that margin, that quality of that margin.
I'm not sure I understand the question, but so the 1,400 hectare, that's the sort of focus of a lot of the assessment. 1,300 of that, 1,303, I think, is in national parks.
That's right.
So
the balance is Crown land, is it?
The balance is Water New South Wales land, I think. Yeah, that's
a
combination of Water New South Wales and Crown.
Right.
So are you asking as if we have baseline data on the quality of many of the attributes in that area?
Yeah, I'd have thought that what we saw was not good quality national park. I mean, a lot of pig damage, horse droppings everywhere, horse hoof marks everywhere, and a lot of weed infestation. This may well be inundated now because it was part of the retreated water, but it was pretty poor.
I think it would be, let me try and answer it in this way. We will not have comprehensive data on the health of that area of land, not systematic comprehensive data. What I can say is that we've significantly increased over the last few years across the parks estate, and including in that area, the level of feral animal control, fire management targets and so on. I can also say I know from speaking myself to various scientists that there are certainly very important areas within the impact area. So there is absolutely no doubt. If your question is this in good shape? I think the answer is going to be there will be areas that have been impacted by fire and by feral animals. That is true. And by weeds. That is true. Some of those impacts will be a result of the original construction of Warragamba Dam. But nevertheless, there is no doubt there are very high conservation values, i.e. it is on the World Heritage List. Not much of the country that is going to be inundated. So, and I think Ms. Sharp mentioned the Regent honeyeater earlier. You know, when you have a bird that is one of the rarest birds in the world, and there are 5, maybe 6 breeding sites, key breeding sites in the country, and this is one of them, then you are talking about a block of land that is very, very important. I hope that answers your question.
Well, I was sort of getting at and you correct me if I'm wrong, but having hiked, of course, into there as well, and I mean, the further away from the water edge, to my layman's eye, it appears to be a better quality national park. There was no apparent serious amounts of damage that we saw right down that water edge.
Sorry, you're saying the further away that you get
I'm saying
the water, the
better. Pull away from that margin that will be inundated is a better quality ecosystem environment.
So it's hard. So it's hard for me to answer your question objectively and with data. So I qualify my answer by that. But I think what you're describing is the fact that the edge of the dam is an area that is impacted, i.e. it's subject to various levels of inundation over time, depending on what's happening in terms of water. And what this proposal will do is expand that area. And in other words, the impact you saw close to the water's edge will now be spread across an extra at least 1,400 hectares.
All right, that's enough questions from me. I don't know if any other government members want to contribute, Taylor or Wes.
I think Polsek for Western Sydney's covered it.
I concur with the Parliamentary Secretary for Upper Hunter.
Thanks, guys.
Oh, the Hunter, Wes.
Then I might just ask a couple of more then if I could, and just a follow-up on Mr. Mallard's line of questioning there, and to you, Mr. Fleming. You know, and I remember seeing that area, which was in the, you know, where the water had retreated zone. I think it would be fair to say that some of those impacts, sediments, weeds, and then they become more attractive often to feral animals, that impact is going to be visited further up into the reaches of the incoming river systems to the dam because of the temporary inundation that would result from this project. Would that be fair?
Yeah, that's correct. I think that was what I was trying to say in my response to Mr. Mallard. I think that's accurate. I mean, Mr. Mallard, you may have been talking about the area effectively below the high water mark, and some of that's actually outside of the park, depending on when you were there and what the level of the water was when you were there. But the general point is the areas that are inundated or temporarily inundated are certainly impacted. And so this proposal will result in more of the national park and the World Heritage Area being impacted in that way.
I got that.
Mr. Knudsen or Mr. Fleming, this may be for you. I'll let you work out who's best to answer it. But it goes to the level of certainty from the current EIS that we can have around impacts based on what has been described by some, and I think acknowledged to a degree by the proponent, certainly Infrastructure New South Wales. We don't know what the operational controls or conditions around the proposed dam wall would be. We don't know how the wall will be operated. We don't know, you know, as a flood mitigation dam, we don't really know how quickly water will be released post a flood, and we don't know how much water by volume would be released during any particular event. All those things seem to me to have some degree of impact, both upstream in terms of periods of inundation and downstream in terms of prolonging flooding events. So I'm trying to understand whether or not you feel you have sufficient information to make a judgment about whether the biodiversity and other environmental impacts associated with this project can be adequately assessed based on the information you have.
I think, Mr. Chair, that given our submission, we wouldn't feel confident at this point with what's been included in the EIS forming a sufficient basis for a final decision. Though I will say that's not all that unusual for it to have an EIS, the first version of it, to have deficiencies. The real test will be what's included in the next version and how adequately they address the series of issues that we've laid out in quite some detail in our response back to planning through to the proponent. The other piece I would say, which I don't think will surprise you, there's always a certain degree of uncertainty with every project. That's where planning needs to weigh up what approach they take with respect to, in effect, the precautionary principle in terms of not only the construction but the operation of the facility, because as you rightly point out, both will have different aspects, and that's a good element to explore with planning and the proponent when you see them this afternoon.
I certainly will. Yeah, go ahead, Mr. Fleming.
I would just add that, what Mr. Knudson's saying, I wanted to sort of, I guess, add to that and reinforce it by saying, I mean, the process is intended to work in a way that you put stuff out, people provide comment, identify the deficiencies, and they should be addressed in the next stage. So what we're seeing is a process by where the issues are getting out there, the issues are attracting comment, and as Mr. Knudsen said, the challenge is for planning and the proponent to address those in the next stage. So the fact that there are issues now is not surprising, nor is it sort of fatal to the project in any way. It's what you would expect at this stage of the process.
So I could understand uncertainties and responding to feedback, but this is sort of central to how this project is going to operate. It's the operational rules for the dam. The entire project is based on flood mitigation, but the rules around how the dam will operate in that way have not been specified. I guess, do you think that they should be specified before the project is actually finally assessed by planning, on the basis that you would need that information to make a final and full judgment about the environmental impacts?
So I'll give a qualified answer. My instinct, right? Because I'm not a biodiversity expert, I'm not a modeler and all that sort of stuff, right? But normally how I've seen this done is you do model that, right? You model what the impacts are of the inundation area, you model the impacts of the operations, you've got different scenarios that you run through to try and to articulate what those potential impacts could look like, and then you build your EIS and the ancillary decisions like offsets, et cetera, accordingly. That is my assumption as to how that type of scenario that you're painting, Mr. Chair, would be dealt with. It'd be through the modeling of the potential impacts. If I have that wrong in any way for this particular project, we'll come back on notice and correct the record. But that is not unusual for us to have some level of uncertainty around the operations of a facility or its potential impacts, but to instead model that and have various scenarios run through. So if I've got that wrong at all, we will come back.
Okay, Mr. Chair, can I add also, you'll be aware, I'll get the legislation wrong, I think it's the Water Management Act or the Water Act, does require an operational, effectively a management plan to be prepared, which I'm pretty sure the Environment Minister has a concurrence role with that management plan. I think that deals with is intended to deal with a lot of the operational detail. You have people from Water New South Wales appearing before you. I'm sure they can provide a more accurate summary of how that regime works.
Are you talking then, Mr. Fleming, about the management plan that was a requirement of the 2018 legislation?
Yeah.
So I think there's a difference. My understanding is there's a difference between that management plan, which seemed to be about how to respond primarily to temporary inundation as a result of the dam wall raising. There's a difference between that and the actual operational rules for how the dam is going to be operated, which could, I think the biggest impact could be that it may well extend the time period of inundation upstream, and that has not been specified in this EIS. I pick up your point about modelling, Mr. Knudsen. I'm not sure if that has been sufficient to recognise the potential differences the operational rules for the dam could have. The suggestion has been made by Infrastructure New South Wales this morning and in other commentary around this project that the government is waiting to understand the conditions that would be put on it by the planning department before they make a judgment about the operational rules. I guess I'm asking, is that good enough given those rules could have a substantive impact on the it's substantive when considering the impacts of this proposal on biodiversity, both upstream and downstream. That's my question to you. Do you have sufficient information without those rules to make a judgment? And if they're not going to be provided until after approval or after consideration by the planning minister, Is that adequate?
Mr. Chair, I very much understand your question, but unfortunately, I don't have a definitive answer for you. I'd have to come back on that to talk or to explain on behalf of my staff, in effect, how they deal with that uncertainty and whether they feel that there is adequacy in terms of what's been provided to date with respect to both the upstream and downstream impacts, because I think both are very relevant. That and I just don't know the answer to it, so I'd have to come back.
Okay, thank you. Well, that's all I have. I'll just go around the room and see if there are any other questions. Anyone raise hands if you do. Then I thank the witnesses for your evidence today and attendance online. I think there were some questions that were taken on notice by you in particular, Mr. Knudsen. The Secretariat will contact you in relation to those. You'll have 21 days based on previous resolutions of the committee to provide answers to those questions. So I thank the witnesses again. I think the committee is now breaking for lunch and will return at 1:15.
Okay, welcome back to this afternoon's session. I now welcome our next witnesses. To start with, I'd ask each of you to state the name and position title, and I will swear an oath for affirmation. I'll just note that Mr. Gainsford, Mr. Harper, you've already, so you'll be questioned today on the previous oath. So could I start then with Ms. Vander Honert? That's your...
Good afternoon. It's Erica Vanden Honert. I'm the Executive Director, Infrastructure Assessments at the Department of Planning and Environment. And I'll do my affirmation. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. Sorry, I didn't hear.
Sorry, I was just asking if Dr. Bentley could please
Sorry, Chair, I think you asked me. Did you? Your microphone seems to be the only one I can't hear.
Okay, hang on.
I know you're talking. But it's really, really faint. But was it me you came to?
It was. Can you hear me better now?
A little bit, yes. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God. And I'm James Michael Bentley, the CEO of the New South Wales water sector within DPE.
Thank you. I will just pause for 1 minute and try and correct my headset. Can I just check with the witnesses if you can hear me better now?
Can you hear me better?
That's much better.
There we go. Thank you. Sorry about that. Mr. Megaharan, is that how I pronounce your name? If you could provide your full name, title, and oath or affirmation, please.
Yes, Ronan Michael McGahern. I'm the Executive Manager of Assets for Water New South Wales, and I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. And Mr. Bob Tilbury.
My name is Bob Tilbury. I am the EIS Project Director from SMEC. I solemnly, sincerely, and truly declare and affirm that the evidence now and about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Now, could I ask if any of the witnesses would like to make a short opening statement, given there's a number of you? Perhaps we could keep it to just a few minutes. I might start with you, Mr. Gainsford.
Yes, thank you, Chair. Thank you for the opportunity to appear before the committee. I am pleased to provide the committee with an update of the environmental impact assessment process for the proposal. The Department of Planning and Environment accepted the Warragamba Dam raising environmental impact statement on the 20th of September 2021, and the EIS was placed on public exhibition commencing on the 29th of September 2021. The department's standard exhibition period is 28 days. However, given the expected high level of public interest in the EIS, the exhibition period was initially set for 45 days to end on the 12th of November 2021. During the exhibition period, the department recognised that there was a high level of interest in this EIS, and in response to requests from the community, extended the exhibition period to 62 days, ending on the 29th of November 2021. The department was made aware that some supporting information had not been included in the EIS for public exhibition. Therefore, the department requested that Water New South Wales provide the missing information and place this on public exhibition with an extended end date on the 19th of December 2021, a total period of 82 days of exhibition. The department notified stakeholders of the updated information and the extension to the 19th of December 2021. The department has provided a copy of all the submissions and a report summarising issues raised in submissions to Water New South Wales now, and requested that a submissions report and a preferred infrastructure report be prepared. A preferred infrastructure report has been requested because we believe further assessment is required to address the issues raised in submissions, and this may result in changes to the proposal. A total of 2,586 submissions were made on the EIS, of which 60 were in support, 2,475 were objections, 53 were from organisations and 7 were from public authorities. This includes 519 emails and hard copy letters received without privacy and/or political donation statements, which will be treated as submissions but will not be published on our website. Once the submissions report and preferred infrastructure report are received from Water New South Wales, the department will determine if a further public exhibition of the preferred infrastructure report is required, and then undertake a detailed assessment of the project, considering the EIS documentation, issues raised in all submissions, and Water New South Wales' response to these issues. At the completion of the assessment report by the department, we will then refer the documentation with a recommendation to the Minister for Planning and Homes. Should the Minister approve the proposal, the Commonwealth Minister for the Environment would also then consider the project in accordance with the Environment Protection and Biodiversity Conservation Act. Thank you.
Thank you, Mr. Gainsford. Could I just, before we move on, Mr. Harper, you've just come on. We just need to do a quick sound check to make sure that you can hear us and we can hear you. You're on mute, or we still can't hear you. Secretary, you might need to provide some assistance. Maybe we can do this via a phone hookup. I might then just move to you, Ms. van der Honert. Do you have a opening statement you'd like to make?
No, thank you.
Okay, thank you. Dr. Bentley.
No, thank you, Chair.
Mr. Megharan.
Yes, thank you, Chair. Thank you for the opportunity to provide evidence to the Select Committee today. To provide the committee some context, the New South Wales Government's flood strategy for the Hawkesbury Nepean is delivering 9 integrated outcomes to reduce the high flood risk that exists downstream of Warragamba Dam. Water New South Wales, as the owner and operator of Warragamba Dam, has been tasked by the New South Wales Government to deliver outcome 2 of the flood strategy, which is to undertake a detailed concept design and obtain environmental planning approvals for the Warragamba Dam raising project. At all times, Water New South Wales has sought to discharge its important responsibilities with transparency and the highest standards of professional integrity. The environmental impact statement was prepared in accordance with the Environmental Planning and Assessment Regulations 2000. The document includes analysis and assessment of the project's potential impacts, including management measures and offsets for unavoidable impacts. The EIS provides extensive detail of the strategic need and justification of the project. Chapter 4 summarises the task force assessment and recommendations of the flood strategy and examines the contemporary analysis and reassessment of flood mitigation alternatives and confirms the proposal to raise Warragamba Dam for flood mitigation as the preferred option. In keeping with an infrastructure proposal of this size, preparation of the EIS was a robust process, including multiple inputs and opinions from professionals and experts. The EIS was developed over 5 years and involved thousands of hours work, field analysis, modelling, and peer review. It contains 29 chapters and 26 appendices and is more than 8,000 pages long. We also undertook an assurance process during the drafting of the EIS, including peer and agency consistency reviews to ensure the approaches and methodologies undertaken complied with the Secretary's Environment Assessment Requirements, or SEARs, and relevant guidelines. Following this process, and after DPI had determined the EIS adequately addressed the SEARs, the EIS was displayed for public exhibition. The public exhibition period of the EIS was of longer duration than most EIS exhibition periods for projects of this size. In response to requests from the public, the Department of Planning, Industry and Environment rightly extended the public exhibition period twice, eventually to 82 days, nearly 3 times the minimum 28 days, and ran from the 29th of September until the 19th of December 2021. The EIS consultation also included 9 public webinars, multiple briefings to local councils, and various stakeholder groups. And 800 copies of the EIS summary were available from 12 civic amenities and public buildings across Western Sydney. The public exhibition for the EIS has now concluded, and with more than 2,000 submissions received by DPI. Over the coming months, New South Wales will consider the matters raised in the submissions and will formally respond to DPI in a submissions report that will be published on the department's major project website. As the project proponent responsible for development of the EIS, New South Wales appreciates the opportunity to be a witness at the Select Committee hearing today, and I'll be happy to take any questions.
Thank you, Mr. Magrahan. Mr. Harper, do we have you?
I can hear you. Can you hear me, Mr. Chair?
We can indeed. I mentioned before that you have already appeared before this committee, so we'll seek your evidence today on the basis of your previous oath or affirmation. Do you have an opening statement?
No, I don't.
Thank you. Mr. Tilbury, do you have an opening statement?
Yes, please, Chair. Thank you for the opportunity to appear before the committee today. My name's Bob Tilbury from SMEC Australia Proprietary Limited, and I've been the project director for the Warragamba Dam Raising EIS since the start of SMEC's engagement 5 years ago. Born out of the Snowy Mountains hydroelectric scheme more than 70 years ago, SMEC Australia is today an Australian-based engineering, management and development consultancy. We provide technical expertise and advanced engineering services, including environmental assessments for significant infrastructure projects. In July 2017, SMEC Australia were contracted by Water New South Wales to conduct the EIS for the Warragamba Dam Raising project. SMEC Australia was specifically engaged to provide objective environmental and social studies, impact assessments and community engagement services, according to a scope which included the Secretary's Environmental Assessment Requirements, or SEARs, for the project. There's no doubt that this EIS is very significant in scale, complexity and detail. It's one of the largest technical assessments ever undertaken in New South Wales, which is reflected in EIS documents that, in order to address the SEARs, total over 8,000 pages. Throughout the entire process, SMEC Australia has ensured that its work and that of its sub-consultants and technical specialists who are engaged to provide inputs to the EIS have met all our obligations under state and federal legislation and guidelines. This included consultation with relevant agencies and stakeholders, throughout the EIS development. As is normal and entirely appropriate, the EIS has been published in full to provide the regulatory agencies and the community with the opportunity to provide their feedback via a submission on the EIS. We're currently in the process of assessing and responding to matters raised in the more than 2,000 submissions that have been received. Our responses to those submissions will be published in a submissions report in the future. I'll be very pleased to help the committee with any questions they have today.
Thank you, Mr. Tilbury. We might start questions today with Ms. Sharp, if you're there. Might come back to.
Sorry, my apologies. My apologies. I'm sorry about that. Thank you, everyone, for coming in today. And I'm not really. I think maybe it's Mr. Gaines, but I'm not quite sure. We've had evidence here this morning, and I'm not sure how many of you were watching or have had this reported. That indicates that you know, the Colin Foundation has some legal advice that suggests that there are deficiencies in the EIS that mean that it could be open for challenge. And I hear what Mr. Tilbury just said in his opening statement, and I've heard of that, but could I get a response from whoever, maybe it's Mr. Gainsford, I think, in relation to that?
Yeah, thanks, Ms. Sharp. Yes, no, I did hear Mr. Chalk's evidence this morning, and I guess that mirrors what was put forward as part of the Colong Foundation submission. I guess all I can say is that we are confident that the department is following due process here. One of the things that Mr. Chalk didn't mention this morning, he referred to the preferred infrastructure report, which I referred to in my opening statement. The department has discretion to determine whether the preferred infrastructure report goes on exhibition. So depending on the information that we get back in the preferred infrastructure report, if we feel that there's a need because of that information that's received to determine that the further public exhibition can occur, then we can progress with that. And that obviously would give the community further opportunity to formally make submissions.
Thank you. And Mr. Gainsford, who decides? So, given the allegations, particularly around the SEARs, who decides whether they're adequate or not?
Yeah, so thanks, Ms. Sharp. So the process that we went through is what we do for all major projects that we receive. So the department, I think I've given some evidence around this in my previous times.
Yeah, I don't want you to have to repeat all of that, sure.
No. So ultimately what we do is once we've received the documentation from, in this case, Water New South Wales, we do, in receiving that information, we do consult with other government agencies to have some confidence that the requirements that have been set in those SEARs have been met. And once we've formed that opinion, we don't do a merit-based assessment. So there's no merit-based assessment at that point in time. It's really making sure that the terms that have been outlined in the SEARs have been met. And once we get to that point, in this case, we got to that point in September, then we determine that the EIS is ready for exhibition, which is what happened.
So if there's a dispute about the adequacy or not, it's really it becomes a legal question, and whether it's challenged or not, making no judgment about whether it would be successful or not. Is that correct?
Well, look, there are legal avenues that people can avail themselves, in terms of those. But what I would say, which is what I've said consistently in previous evidence, is that the EIS is one step in the process. There are, as I mentioned, opportunities through the response to submissions and also preferred infrastructure report to provide additional information and to continue to address, I guess, the requirements that have been set in those SEARs.
Thank you. That's very helpful. And I wanted to understand, so there's been a lot of discussion, and I'm glad that people have seen it this morning around the potential need for legislative change as a result of the approval and whether there's been legislation drafted. Are you aware of whether any legislation has been drafted that would, in relation to allowing the dam to proceed?
I'm not aware. No, I'm not aware.
Is there anyone else? Maybe Water New South Wales?
No, I'm not aware of any legislation which has been drafted in that respect.
Thank you. And I wanted to, we had a lot of discussion this morning, and a lot of the agencies pointed back at the group of people sitting here in relation to it being a question for you. I wanted to understand where discussions with the Commonwealth are in relation to the EPBC Act and any approvals that would need to go through there.
Yes, I can answer that, Ms. Sharp. So, and I've heard the evidence that was given by Mr. Fleming and Mr. Knudsen earlier today, and I think that was spot on in terms of the description around our engagement with the Commonwealth. So yes, we have regular engagement with the Commonwealth with regard to the assessment that we do on behalf of the Commonwealth, and ultimately, as Mr. Knudsen said, once that assessment has been completed with the advice from EES and other government agencies, then we'll refer that assessment across to the Commonwealth, and it'll be up to the Environment Minister at the Commonwealth level to make a decision. So we have regular and ongoing conversations with the Commonwealth. We've actually got an embedded officer from the Department of Agriculture, Water and Environment that actually works closely with our assessment team. So we have lots of engagement with them. And
what is the sort of the time frame from here to the start of construction? You know, what time frame are we looking at for a decision point in the first instance, and then the starting of construction if approved?
I think that would be a question better for Water New South Wales in terms of the timeframes.
Yeah, thank you, Mr. Gainsford. I think obviously we have just received, as I pointed out in my opening statement, and Mr. Gainsford has pointed out, a large number of submissions which we now need to work through and provide to the department in the form of a submissions report. We still are establishing what we believe is the timeframe we're going to need to respond to those adequately, and as such that's where we are in the process. The process will then hand over to Mr. Gainsford and assessing that and what next steps need to be taken in terms of determining the EIS.
So just thank you for that. That is the process, but I'm trying to get a ball, you know, are you able to give me any ball, but you know, how long do you think that's going to take you, Water New South Wales, to get that point where it then goes to planning?
Yeah, we're still working through that, as you appreciate.
A month? Yes, no, I appreciate it, but you know, a month, 3 months, 6 months?
It certainly will be more than a month. It will be months.
Okay, 3 months. I'm not going to hold you to. I'm not trying to hold you to it. I'm just trying to get an understanding of what the time frame is in terms of decision making.
I'm happy to take that on notice and come back to you with an estimate through discussion with the team to understand what we believe we can do.
Thank you. And I think maybe Mr. Gainsford, this is one for you. The preferred infrastructure report, is that something that you do? If it goes ahead?
No. So this is a document that that Water New South Wales prepares, which is a document that sits next to the response to submissions, and basically that document outlines any design changes, any further additional assessment work that has been conducted as part of, I guess, the response to those submissions.
Okay. And Mr. Magaharan, does that mean that you would, so you anticipating that that report would come forward with the submissions to then go to planning?
Yeah, as I currently understand. So we will be reviewing the submissions. Those submissions, then we need to consider and understand if any of those submissions would propose any changes to what the design of the project, and then we'd be submitting that with the submissions report.
And just to be clear then, Mr. Gainsford, it's up to this discretion on your behalf about whether that's then publicly exhibited again.
Yeah, that's correct. So we just to be clear, all documentation that we receive once we receive the response to submissions and the preferred infrastructure report will be made public. So we'll put it up on our website as soon as that information is received. The discretion that we have is whether we choose to exhibit the preferred infrastructure report and in effect solicit further submissions from the public.
Great, thank you. I might hand over to my colleagues. I've got more questions, but I'll let them have a go. Thank you.
Yeah, I've got some questions if that's okay. Well, I'll proceed until interrupted. This is a question to Water New South Wales. Ms. Sharp asked about whether or not any legislation had been prepared in relation to the issue of statutory limitation of liability for the operator of the dam. I think the answer was no. But has Water New South Wales sought from government as part of this process any commitment to such legislation? Bearing in mind there's a 2015 document from Water New South Wales saying that extensive legislative change around those issues for directors, officers, and others in relation to the operation of the dam was necessary as part of this project.
Yeah, thank you for that question. I might first say if the project was to proceed, there are a number of elements related with Water New South Wales operating licence and its works approval, which would need to be made, a change would need to be made to as a result of the change in operation of the dam. The item which you refer to, I'd have to take on notice and understand that further to provide the committee an adequate response.
By the item, you mean the document I was referring to?
I don't have a copy of that document.
Give you the full name. It's the Hawkesbury. And I'm happy to provide a copy of this to the committee so it can be forwarded to you, so you can take this on notice. It's the Hawkesbury Nepean Valley Flood Management Task Force. It's dated July 2015, and it says Water New South Wales would require amendments to its enabling legislation to provide a complete statutory limitation of liability to the operator, its directors, officers and employees for actions taken by Water New South Wales in discharging its statutory duty, a comprehensive dictionary / set of definitions as part of the amendment of legislation is required to provide clear direction. It goes on basically detailing, from my perspective, a quite extensive list of legislative amendments that are necessary in the view of Water New South Wales. Just going back to your evidence a moment ago, is it the case that from your perspective or from the perspective of Water New South Wales that the changes that you've just touched on are actually necessary for this project? They're not kind of just, they would be good, but they're actually necessary to deal with the changed operation?
Certainly the changes I mentioned, so potential changes to the operating licence and the works approval and the Water Management Act would need to be changed. Now that, as I understand it, does not require legislation to do that. They can be done as is through the department.
What if those changes to the legislation that you've touched on are not forthcoming? What would be the consequence for this project?
So just to clarify, that changes to the operating licence and the works approval would not require any change of legislation. Those changes would enable Water New South Wales to operate Warragamba Dam as a flood mitigation dam. So at present, operating licence and the works approval does not allow for Water New South Wales to operate the dam as a flood mitigation dam. It is its sole purpose is for drinking water for the city.
Is it your evidence that any legislative changes are necessary?
I'm not aware, and I would have to take that on notice to understand that in more detail. But as it stands, we do know that those changes to our works approval, our operating licence, would be required.
Perhaps I could ask.
We can't hear you, Justin.
Mr. Bentley, can you hear me?
I can now.
Recently,
sorry, Mr. Sterler, I'm unable to hear you. You keep dropping out.
Sorry, I'm now addressing my questions to Dr. Bentley. Can he hear me?
Yes, I can.
Yes. Now, you recently wrote to the former Environment Minister, Mr. Debus, in his capacity as chair of the Colong Foundation, didn't you?
I don't recall, but if you have a document in front of you, I'll accept that. But I don't recall that letter.
Okay, well, I do have that document in front of me, and it does say that it does touch on the need for change legislation in this area. What can you tell the committee about the need for changes in the legislation for Water New South Wales to make this project a reality?
I can't add to anything that Water New South Wales has just said. Water New South Wales is the owner and operator of the dam and is the proponent of the project, and it's not within my job to run this project for them, as it were. So I can't add to anything that Ronan's just said, and I would support what he has said.
I have to leave it there as you don't have a copy of the correspondence in front of you, but I might come back to that. Mr. Chair, I might just put a pin in that and see if anybody else has questions. I do have questions for other witnesses, but I'm perhaps happy to do them a little bit later.
Could I just check that people can hear me now? Thank you.
Sorry, Justin, we could when you asked, and then as soon as you asked, it went terribly.
On to others. Okay, let's see. Dr. Bentley, I have that same letter in front of me that Mr. Searle was mentioning. Clearly, it's a response to Mr. Debus, and you specifically respond with regards to legislative changes around the operation of the dam, and then say, and I quote, "In terms of any changed liability, along the lines of any legislative change required for the dam wall raising, this would be considered by government at the appropriate time." I know that doesn't necessarily give anything away there, but clearly the Secretary asked you to respond to this question on their behalf. I'm just wondering, what are the potential liability issues that would need to be considered? Clearly, you felt the need to respond to suggest they will be considered at the right time. So I'm just wondering the nature of the liability issues that the department and the government are concerned about.
Yeah, but I'm not qualified to answer that question. My answer is that my answer in that letter, which I don't have in front of me, but one of my colleagues is sourcing for me so that I will be able to read it. But if my answer was that whether any legislation change is required will be considered in due course. That's not me suggesting that I know that there will be a change required, and it's not me that would be doing that review. So, you know, it's my role as the lead for water within DPE has very little touch on this project, because this project is a flood project, not a water project as such. And I know flooding and water are very closely related, but it's very important that I don't meddle in things that are someone else's responsibility, particularly when they're of such an important nature as this. So I don't meddle in those things, but that response on behalf of the Secretary, as it were, I think was stating what is obviously fact, that whether such change will be required will be considered in due course, but I'm not the person to do that consideration.
Just on that point, Mr. Bentley, you're not aware of that earlier document from Water New South Wales saying that legislative change in this area was needed?
No, I'm not.
Then I might ask this of Mr. Magaran in the first instance. Does Water New South Wales have a view about whether it can operate the dam as a flood mitigation dam without some sort of protection from liability for the operation of the dam in that way?
Much like I said earlier, as I understand, we would need operating licence changed and our works approval changed to allow us to operate that dam as a flood mitigation dam. I do not have in front of me an understanding of the view whether or not any legislation would be required to be changed, nor anything else related to that. As I said, I'm happy to take it on notice and provide further evidence for the committee.
So I'm not talking about the operation of the wall itself, of the dam itself, the operating licence or works approvals. I'm talking about, as that 2015 document alluded to, liability issues associated with the operation of the dam. The suggestion from that letter was that it created liability issues for the government, and I inferred from that legislative change may well be required to limit the potential liability on the dam operator should something go wrong, should downstream properties be flooded as a result of the management of the dam in that way. Is there anyone on this panel that can speak to that potential risk? Has government sought advice around that risk, quantified that risk in any way, or is everyone just flying blind about that risk? Perhaps I'll start with the Water New South Wales reps and go from there.
I can't add anything further to what I've said at this point.
Then, Mr. Gainsford, I don't know where the planning department comes in consideration of these issues. Obviously, you're making a judgment about, and the minister ultimately will make a judgment about the approval. Where do those considerations fit into the planning assessment, if at all?
Mr. Field, I mean, ultimately, we make decisions in accordance with the Environmental Planning and Assessment Act. It's common practice for developments to have to seek other licenses or approvals under other legislation. So whilst our expectation would be that that those sorts of issues would be discussed and part of an assessment process, ultimately what happens under those other bits of legislation is not a matter that we consider as part of our finalisation of assessment.
Okay. I do have one follow-up before Mr. Tilbury. I'd like to direct some questions to you, but to Mr. Gainsford, a follow-up to the questions that came from Ms. Sharp earlier. What is the threshold, in your view, for making a decision about whether or not the preferred infrastructure report would go out for public consultation?
Yes, thank you, Mr. Field. So ultimately, the discretionary part of that is really if our view is that there's sufficient new assessment information or sufficient change to the development which would be of interest to people, then we would use our discretion to put it on public exhibition.
Whose call is it? I'm not sure if you specified earlier to Ms. Sharp's questions. Is it yours or the minister's?
Oh, look, I mean, it is the department's. It probably does lie with me under delegation, but it is a role that the department plays and has discretion under the legislation to make that decision.
Now, we obviously had a discussion around some of these questions at a former hearing where I guess there was a preliminary view put by agencies around the draft EIS. Some of those were leaked. I think, Mr. Gainsford, you were at that hearing, and we were told that there's been this ongoing engagement between planning, the agencies, and the proponent to address those issues. How did we get to a point where the EIS was so inadequate that this additional work would need to be done and a PIR be prepared when there's been active engagement with the planning department between the interested agencies and the proponent?
So what I would say, Mr. Field, is that this is not unusual. We do, for complex infrastructure projects, quite often have preferred infrastructure reports. That's a document that, so as an example, for a current project that we're considering, the beaches link, that's a preferred infrastructure report requirement for that development. So this isn't unusual. To the other point of your question around, I guess, my previous evidence and discussion around the draft EIS and progressing that to an EIS exhibition, yes, there was lots of engagement with Water New South Wales and with agencies. Our interest was really to ensure that the issues that have been raised around the draft EIS were as much as possible addressed, so that we could progress the EIS to a public exhibition, because I think it was in our interest and I think the public's interest to have an EIS that was on exhibition and enabling people to view the complete documentation and provide the submissions. But again, I would highlight the fact that we and the other agencies at that point in time, prior to the EIS going on exhibition, were not doing a merit-based assessment. It was primarily to make sure that the issues that, or the terms of reference, if you like, in those assessment requirements were sufficiently addressed that it enabled the exhibition of the EIS to occur, and that's the judgment that we came to.
You can understand a private developer trying to push the limits like this, but we're talking about government agencies here. And I think the fact that it wasn't a merit-based assessment, it was really an analysis of adequacy against the SEERs, points to a really troublesome situation where Water New South Wales ultimately submitted an EIS that did not address the requirements of the SEERs, which is quite evident now based on the fact that you've pushed back and they have to do a preferred infrastructure report. That wouldn't be usual, would it?
So, Mr. Field, I guess I would draw some distinction there, that I think a lot of the advice that we've now received from agencies, and obviously there's been a number of submissions which I referred to as well, that have raised concerns and issues. Quite a few of those issues are really around some of the merits of the proposal. So I would draw some distinction between, I guess, the advice that we received prior to the EIS going on exhibition and the advice that we've now received subsequent to the EIS exhibition.
I won't push that one. I think it's evident to everyone how we've gotten here. Mr. Tilbury, has SMEC been engaged to do any additional work for Water New South Wales on the preferred infrastructure report?
Thank you, Mr. Chair. Not as yet. Our work is to assess the submissions that have been received and respond to those submissions and help prepare the submissions report. We've not yet addressed the question of a preferred infrastructure report. That's really a matter for Water New South Wales, I think.
Okay. And responding to the submissions, putting together that response, analysing the submissions, was that part of the original contract?
Yes, it was.
So, obviously, you've done the bulk of the work on this EIS on behalf of Water New South Wales. It's come in for a bit of criticism from agencies well ahead of now, and also now that the EIS has been formally lodged. I guess I just offer you an opportunity to comment on where you think things might have gone a bit astray in getting an EIS completed that met the requirements of the SEERs, which you acknowledged in your opening statement was the requirement of the contract.
Well, firstly, I would say this situation's not unusual to us. It is common on large projects to receive a significant amount and detail of submissions on the EIS documents. So we followed the process. The EIS, draft EIS, was provided to planning for consistency review and approved for public exhibition, as Mr. Gainsford's described. And the process from there is not unusual. That's we acknowledge that's not a merit assessment, that's a consistency assessment. So not unusual, and if there are issues raised in those submissions that require further assessment, then we'll include those in the submissions report.
Okay. Are you able to provide the committee with advice on the value of this contract to SMEC?
I think that's a matter of commercial in confidence between SMEC and Water New South Wales. Happy for you to direct that question to Water New South Wales if you choose.
Have you had to renegotiate the contract at any stage during its life?
There have been changes to the contract as it proceeded, as is normal with most significant contracts.
There's been obviously some public discussion about the concerns raised by staff who had worked on this project about the process. So I guess I'd just put to you, have you found working with Water New South Wales, or have you found, or do you have a view about whether or not Water New South Wales have administered this contract fairly and in good faith?
Oh, I couldn't say I have a view on that, Mr. Chair. It's a large, complex contract, a piece of work that's significant, has spanned a good period of time. So, but my short answer would be we're happy with the administration of the contract.
So we heard previously from Ms. Rachel Musgrave, who I know worked on this contract, concerns that the report was changed in some ways from her advice. I think I'm not misrepresenting that previous evidence. Did you have a role in changing the work that Ms. Musgrave had done?
Not me personally, Mr. Field, but certainly the work was subject to a standard peer technical review process, and as a result of that process, some changes to wording were made.
And can you just talk to how that process actually worked in terms of engagement with Ms. Musgrave, your other employees, I guess, who have worked on the contract, and Water New South Wales? What was the process that went through to get that ultimately changed?
So, as is standard with large technical and scientific studies, they are all subject to peer review, and so the wording of some sections of the EIS were peer reviewed internally by SMEC staff, senior technical staff with significant experience in environmental impact assessments. There was an interpretation of the framework for biodiversity that was not binary, required assessment of a number of different factors. As a result of those technical reviews, there was a change to wording that we felt better reflected uncertainty around what the impacts to some aspects of biodiversity might have been.
So I'm familiar with these sort of peer review processes. Was that done before it was submitted to Water New South Wales?
I think over a 5-year period, many drafts of chapters and sections of the EIS were produced. So I couldn't say for sure, but I would say that they were contemporaneous with reviews by technical peer reviews, also by Water New South Wales specialists.
So some of it might have been in response to Water New South Wales pushing back on particular elements, and then there was a peer review done by senior staff and changes were subsequently made.
We received commentary from Water New South Wales. We received that in the form of comments on different sections of the EIS. We considered the comments, but that doesn't mean we adopted the comments. So our own internal staff made technical assessments of the appropriateness of the wording of the EIS. And as a result, some of those changes were made, and they were the responsibility of SMEC.
Mr. Searle, I think I noted that you might have wanted to jump in there.
Yeah, just on that point, Mr. Tilbury, the evidence this committee's received previously from Ms. Musgrave and Dr. Crates wasn't some kind of minor or in the ordinary course peer-reviewed modifications as part of a usual process. The evidence, if I'm not putting it too highly, was that they both felt that the substance of their work was being changed in a way that was not appropriate, and that was coming, the pressure was coming down onto them from management at SMEC as a result of pressure from Water New South Wales. Now, are you telling us that that just didn't happen and that their evidence to this committee is not correct?
I can't comment on their feelings and how they perceive.
I'm asking about their professional judgments here. They felt their evidence was that their professional work was being compromised.
Chair, I'm going to have to raise a point of order at that point. The witness was only words into his answer when he was interrupted by the Honourable Adam Searle. I'd ask that the witnesses be given the opportunity to respond. Obviously, with the WebEx system, there is a little bit of delay. And so I think that we all need to be a little bit patient and allow witnesses to finish speaking before we ask another question.
Look, I take the point. I think the exchange has been pretty respectful to date. We've all seen the evidence before the committee, so I think it's reasonable to ask these questions and to allow them to be answered. But thank you, Mr. Searle.
I think Mr. Tilbury was in the process of responding.
So my response is that it was a normal technical peer review process. So it's not these assessments are not completed by one individual. They are subject to normal technical peer review.
Perhaps I can ask Water New South just again, sort of, whether any actions have conducted into the allegations made by Musgrave and Dr. Crates made at the previous hearing of this inquiry, and if so, what the outcomes of those investigations were.
Sorry, Mr. Searle, I was unable to hear your full question. I'm not sure if that was directed at Water New South Wales.
It was directed to Water New South Wales, and I think it was directed to Mr. Gainsford, but perhaps he's not the right. If you're the right person, whoever the right person is, the question is whether or not any investigations have been conducted into the allegations made by Ms. Musgrave and Dr. Crates at the previous hearing of this committee, that their work was, in essence, interfered with improperly, inappropriately.
I'm happy to respond to that question, Mr. Searle. And obviously, Water New South Wales is aware of the allegations made at the previous hearing, and I would like to make a number of points in relation to this, both in response to allegations, but also those steps taken in developing the EIS. Following that evidence, DPIE Planning and EES wrote to Water New South Wales to seek additional factual information relating to those allegations. to inform Water New South Wales response on the 25th of November 2021, we engaged an external law firm, Minter Ellisons. As a consequence of that retainer, Minter Ellisons has made inquiries about the factual circumstances surrounding these allegations. At this point, that work is ongoing, and as you would appreciate, not be appropriate for me to speculate on this matter while the process is still underway. I would, however, like to make the following general comments about the process and developing the EIS as for some of the points that Mr. Tilbury's made. Throughout the development of the EIS, it has been subject to rigorous peer review, and which has been robust, and it's not uncommon through this kind of process for various experts to have different views and ultimately assess the impact associated with the project. I note that in characterising the future impacts of the temporary inundation, that was quite a careful consideration, and much of the discussion of the evidence was provided around that. Where appropriate, evidence was requested throughout that process to ensure that it could back the statements. And in completing the EIS, and separate to any internal review that SMEC conducted, Water New South Wales also conducted assurance processes. So we engaged separate experts, Cardno, to complete both a technical review and also a separate legal firm to complete a legal review of the EIS. These reviews were obviously in addition to those reviews that were undertaken and the feedback which has been talked about by the relevant agencies on the draft EIS. And that feedback was taken on board and it was addressed in the EIS that has now been placed on public exhibition. So right now, and as per the requirements of the planning process that we've already discussed, we will respond transparently to each of those submissions in relation to that through the submissions process. Finally, I'd like to make the point that much of the commentary has been centred on direct and indirect, and I note that the approach as presented in the draft EIS was really about that commentary. This included us taking an agreed approach with the relevant agencies for determining an impact area, which has been used for the purposes of the FBA. And for clarity, this approach, as I said, was agreed by all the agencies, and with the impact area in the EIS now takes a precautionary approach to the upstream inundation area and impact for this project, and assumes full loss in that impact area.
Got a couple of follow-on questions, Mr. Chair, for Mr. Marginson. In relation to those investigations being conducted by the external law firm, do you have an estimated time frame within which you think they will be completed?
We understand that will be completed in the coming weeks.
Given evidence that has come before it?
Sorry, Mr. Searle, was unable to hear you.
Will you inform the committee of the outcome of those investigations?
At this point, it's not appropriate for me to discuss or speculate that matter while that process is still underway.
Now, I'm not sure whether this question should be directed to you or to Mr. Harper, but given the substantial shortcomings identified by various government agencies to do with the EIS, is Water New South Wales happy with the EIS that has been prepared by SMEC?
Water New South Wales, as I stated, has gone through a very rigorous process with SMEC in developing the EIS. That EIS has been put on public exhibition, and as per the process, we're now reviewing the submissions that have been received. As has been stated by others here today, that it is not unusual to receive feedback on an EIS, and I think it's a very robust part of the process where the public has an opportunity to review and respond, and then Water New South Wales will consider all that feedback and provide that in the form of a submissions report to the department for then that to be considered further.
But are you happy with the
Sorry, no, Mr. Sell.
I heard what you said, but the question is, was Water New South Wales happy with the work done by SMEC on the EIS?
Water New South Wales has continued to work with SMEC on the development of the EIS, and we have put the EIS as agreed by the department on public exhibition as it was deemed adequate.
Well, I don't want to put words in your mouth, but I've now given you 2 opportunities to say that Water New South Wales was happy with the EIS prepared by SMEC, and it's just a matter of record that you have twice not taken up that opportunity. Is that correct?
Water New South Wales has a contract with SMEC, and we continue to work with SMEC on delivering the requirements and the outcomes of that contract. We still have further work to do, and we're continuing to work with SMEC throughout the process to develop the submissions report.
Sorry, Mr. Sell, could I just jump in there? And I'll give you a chance on this, but I've certainly heard information to this effect. Has there been any threats of legal action from SMEC to Water New South Wales with regards to this contract?
Not that I'm aware of.
Okay. Potentially, Mr. Tilbury, would you be able to confirm that's the case, that SMEC's not made any threats, legal threats with regards to the operation of this contract and the ongoing nature of this contract?
No, we have not taken any legal action in relation to this contract.
Have you made suggestions in writing that legal action may be taken should there not be agreements around aspects of the contract?
No.
No, okay. Then I might just finish off on the line of questioning I had around Ms. Musgrave, if I could, and then I'll open up the questions to other committee members. Mr. Tilbury, the committee previously received and tabled correspondence from and including yourself and Ms. Musgrave and others at SMEC, outlining her concerns about changes made to the report and changes that she believed put at risk her accreditation as an accredited assessor. Her name, of course, was kept on the report as the accredited assessor despite her raising these concerns. Can you explain why her name ultimately was maintained on the report when she had raised these concerns?
Thank you. In fact, we had agreed to remove Ms. Musgrave's name from the report at that point. It was, in fact, an editorial error that it remained on the report at that particular point in time.
Okay, and to the concerns that she had expressed in these letters, and I'm sorry, they were previously tabled, but I don't have one to be able to share with you right now, and I'm happy if you want to take it on notice. But she explicitly raised concerns about the degree to which the proponent was pushing back on aspects of her assessment and her disagreement that the language that ultimately was agreed upon through the internal processes of SMEC sufficiently retained the sentiment around her assessment of biodiversity impacts. Can you speak to that?
So I think, as I said earlier, we certainly undertook our own internal technical peer review, as well as receiving peer review commentary from Water New South Wales. We assessed the comments received from Water New South Wales, and our technical team made decisions around changes to the wording in the document.
But you'd accept that the initial process that kicked off this assessment in that regard was concerns raised by Water New South Wales?
No, I don't agree with that statement. This issue around direct and indirect and the way particularly the upstream biodiversity was to be assessed was a very complex technical matter, and our senior technical staff came to a conclusion that the impacts upstream of the dam could be described as infrequent, cumulative, and or difficult to measure, which is in line with the definitions in the Framework for Biodiversity for indirect impacts. And as previously presented to the committee, there was an agreed approach amongst agencies that an area upstream of the dam would be described as an impact area, and that provided a precautionary view of an area that would likely be impacted or considered likely to be impacted for the purposes of assessing offsets required for the project.
So I think what you've suggested there, Mr. Tilbury, and I don't want to put words in your mouth, so I'll give you a chance to confirm this if I've got it wrong. But it seemed that SMEC was involved in this agreement that was reached between agencies about how impacts were going to be assessed. And instead of using the Framework for Biodiversity Assessment, there was this agreement, and direct versus indirect impacts, there was this agreement around impacts that was reached. And I guess this goes to one of the concerns raised around the 20-year average as it was described this morning. And I'm trying to keep it simple, but that's sort of the easiest way to describe it. And that SMEC was sort of involved in those discussions, and ultimately the report was written to reflect that agreement between agencies about how those offset requirements were going to be addressed. Is that right?
So to clarify, SMEC was not involved in those discussions directly, but this was a complex technical issue where we sought, or Water New South Wales rather, sought clarity amongst agencies. That discussion took place and ultimately resulted in the approach to upstream assessment that was presented in the EIS.
You could see how an accredited assessor writing the report that all of a sudden had that sort of direction given would feel that their work was being changed and it wasn't necessarily consistent with how an assessment might be conducted in normal times.
I can't comment on how Ms. Musgrave felt about that.
It does seem here that you've got a situation where experts commissioned to do an EIS were effectively directed by the proponent about how to assess the offset requirements for that project.
I don't agree that the proponent directed the assessment.
Okay. Could I thank you, Mr. Tilbury? I appreciate your responses there. Can I just check in with the Deputy Chair in the first instance?
Nothing, thanks, Mr. Chair. Mr. Saul covered my line of questioning next.
Then members of the government, Mr. Mallard or Mr. Martin or Mr. Fang. I think that they might have stepped out for another one. Oh, Wes?
I just wanted to say that I'm good with the questioning for the moment, so I'm happy just to continue to monitor.
Okay. Then I might just check in with Mr. Searle if you wanted to continue.
Yes. Yes, thank you, Mr. Chair. I wanted to ask, again, I'm not sure whether Mr. Marguson is the right person, but Margaret, sorry, we might start with this question, which is the in relation to the Aboriginal cultural values. Why didn't Water New South Wales not assess Aboriginal cultural values as part of the World Heritage Assessment when the cultural heritage of the Blue Mountains is explicitly stated in the UNESCO listing criteria? How could such an oversight have occurred?
Yeah, thank you, Mr. Searle. And I point the committee to Chapter 20 of the EIS, which covers the protected and sensitive lands, details the assessment undertaken on World Heritage status. Noting ultimately that assessment of this work is up to the department and the process in the EIS assessment. The EIS, I think, in that chapter demonstrates that we did assess that, but obviously we've received feedback from the throughout the submission process that it has not been done sufficiently. And like all that feedback raised through that process, Water New South Wales will review and respond to that feedback in the submissions report.
Well, given the strength of those criticisms, can you tell the committee what steps Water New South Wales will take to come to grips with those criticisms?
Yeah, so with SMEC, we are reviewing that in detail, and we are going to take the steps required to address those in our submissions report. The World Heritage Assessment certainly includes considerations from the Aboriginal Cultural Heritage Assessment that was completed, and so there is information there, as I said, in Chapter 20, plus one of the supporting appendices. So we'll be reviewing the detail that we provided and assuring that we address the comments made through the submissions.
If I might, Mr. Searle, I could also direct the committee to Appendix J, Section 6.1, which has a description of Aboriginal cultural heritage values in the World Heritage Area. But we will respond to the submissions that have been received on that matter.
Thank you for that, Mr. Tilbury. Can you tell the committee who wrote Appendix J, or what were the qualifications of the person or persons who did do Appendix J?
The qualifications is a technical principal in environment and planning at SMEC.
SMEC employee?
Yes, but obviously that chapter is based on a number of other technical reports contained in the EIS.
But they won't.
Sorry, Mr. Searle, I couldn't hear that last piece.
They weren't an expert in making cultural assessments.
No, they relied upon the specialist cultural heritage assessments in other chapters, such as Appendix K and Chapter 18.
Perhaps I could go back to Mr. Margarin. How does Water New South Wales plan to fund this project if it is to be ongoing? Has there been, or have you sought any commitment from the New South Wales government around funding?
Can I just clarify that question, Mr. Searle? We're talking about the completion of the process we're currently in, or the project, construction of the project?
I was referring to the construction of the project. Where are you up to with government and over the funding, or how does, what's Water New South Wales's plan on how it would have the project funded?
So that process is ongoing, and that is ultimately a decision which will be made by government if the project does proceed. But there's certainly been initial work started on the options to fund that.
I don't think anyone heard that, Mr. Searle.
I just wanted to see if anybody else had any questions. I don't wish to monopolise it.
No, I'm happy to jump in for a little bit. I wanted to, I guess, continue with some of my questions from earlier, but this time redirect them to Water New South Wales. So potentially you, Mr. Magaran. The contract with SMEC, are you able to provide the committee with advice on the value of the contract to prepare the EIS?
Look, I don't have that number in front of me, but I understand those figures are available on our website in annual reporting.
Okay, I'll have a look there. Can you provide us with advice on how many times the contract has been renegotiated since it? I think it was initially 2017 when it was started.
No, I would not be able to provide you that advice here today. I don't have that in front of me.
Take it on notice.
Sure. Yep, absolutely.
Great. That would be great. Thank you. Now, obviously, you've been directed by the department to prepare a preferred infrastructure report. Who do you intend to do that work?
As I understand, as part of the original scope, that was part of SMEC's contract, but I'm happy to take that on notice. The process of creating a PIR is obviously highly connected to the submissions report and understanding the impact as a result of those submissions. So yeah, that is my understanding as it is today.
I think Mr. Tilbury just said before that they weren't responsible for the PIR or hadn't heard about how Water New South Wales wanted to go about preparing the PIR. Mr. Tilbury, maybe you can just confirm that that's the case. Is SMEC doing the PIR or not?
Thank you, Mr. Chair. My earlier comment, I think, and correct me if I was wrong, said we hadn't contemplated as yet the commencement of a PIR. It is in our contract that, if necessary, we would assist with the preparation of a PIR. But as you also heard from other witnesses, PIR is discretionary. So at the time of the contract, it was not clear in scope whether it would be required or not.
Well, can you say whether or not the development of the PIR is currently funded under the contract, or whether or not it would require a clarification and change with regards to funding?
Well, I think that's a commercial matter between Water New South Wales and ourselves.
Far be me try to coordinate your contract agreements in the committee, but Mr. Magaran, can you confirm, is it your understanding that that's funded, or you need more funding to continue that work with SMEC?
I'll ask Mr. Harper to respond.
Thank you, Mr. Chair. Can you hear me?
I can.
Yeah, I didn't want to come off the mute. It'll upset the speaker at the other end, I understand. But to answer your question, the PIR, as Mr. Tilbury's already pointed out, was part of the scope. Whether it was needed or not was not known at the time. However, there's sufficient funds for undertaking the PIR. The PIR would have to be developed probably in collaboration with ourselves, because it probably has potentially design infrastructure changes, which is the whole purpose of the PIR.
Okay. Well, it seems like you haven't started that process yet. The discussions haven't started. It's a highly technical piece, I think, as Mr. Magaran mentioned. There was some discussion about timeframes, I think, earlier in today's session, maybe as short as 3 months. Mr. Tilbury, can you give us any advice on how long you would think it would take to prepare a PIR for Water New South Wales?
I can't speculate on the time frame required. The main purpose of a PIR involves whether there are infrastructure changes to the proposal, and that is not in our scope. So I would have to defer to Water New South Wales on that point.
Okay, we've got a few hands coming up here now. Mr. Harper, I might get you to clarify first, and then I'll throw to you, Dr. Bentley.
So, as I said before, it is funded. The PIR will be undertaken, commenced after we've unpacked all the submissions, which we're currently doing and working through them, as Ms. Magaran pointed out. The PIR probably won't be as extensive as the submissions report, I would say, from what we've gathered so far to date.
And Dr. Bentley, did you have something to add?
Just very briefly, thank you, Chair. And I'm trying to be helpful here, not anything other. I think in your question you said maybe as little as 3 months. I don't think Warden New South Wales gave any information about timescale other than to say they'll go away and come back with a timescale for you.
Okay, I didn't mean to misrepresent that. I must have misheard, and maybe that was in regards to the response to submissions anyway. So I certainly don't want to confuse the record there. Thank you, Dr. Bentley. Thank you. That sort of concludes my line of questioning around that element. I was hoping to go to the World Heritage Assessment. It's quite clear UNESCO has concerns around this project and think that, and I think it's unfair to say that they feel it's inconsistent with Australia's obligation under the World Heritage Convention. And that's subsequent to the EIS coming out. So we've sort of moved on from where we've asked questions around this before because the EIS is now completed and they've had a chance to see the assessment. So can I get a clarification, I guess possibly Mr. Gainsford, it's from you, about what is the engagement with the planning department with the World Heritage side of this question now, working with UNESCO to ensure that it will meet Australia's obligations. And I appreciate that it's also there's federal ramifications here, but ultimately the planning minister makes decisions before it even goes there for, I guess, concurrence to a degree. So can you explain how that will work now?
Yeah, thank you, Chair. So as you mentioned, we have now received a submission coming from UNESCO, which also contained advice from the International Union for the Conservation of Nature. And so as part of that process, we've submitted that to Water New South Wales again as something to be responded to, along with the other submissions. With regard to our engagement directly with UNESCO, we don't have a direct engagement with UNESCO. That has been done through the Commonwealth. The Commonwealth are the ones that administer World Heritage. And obviously, as I mentioned in my earlier evidence, we do have regular conversations with the Commonwealth about a range of matters, including the EPBC Act assessments that we're doing on their behalf. But it is the Commonwealth that have the direct engagement with UNESCO, but we've received that submission and submitted it to Water New South Wales.
Okay. Now, if ultimately UNESCO doesn't support the project, I guess that is a question for the federal government, what they do about that, whether or not they would be prepared to sign off on the project if it didn't meet World Heritage obligations, or is that not the case? It still could well be approved even if it's assessed as not meeting World Heritage obligations.
Chair, I guess my expectation again would be, as per all the submissions that have been received, is that Water New South Wales will be able to respond and address the issues that have been raised. And I don't want to speculate, but I guess we would be seeking some further advice through the Commonwealth of UNESCO and those players at that point in time.
Okay. So we've obviously seen the public submissions to the EIS, but in these interchanges between the Commonwealth and the states around this question, is any of that evidence going to be made public, or is that largely between the department and the Commonwealth Department now in terms of negotiating on how those issues raised will be addressed?
So can I just clarify, Chair? Are you talking about the regular meetings and dialogue that we have with the Commonwealth, or obviously there's formal bits of advice and submissions that we've published? Are you referring to things outside of that?
Well, yes. Now that we've seen the public submissions, including IUCN's review, obviously you've sent advice back to Water New South Wales. They'll respond, but there will be this ongoing interaction with the Commonwealth around both World Heritage issues and ultimately EPBC. Is any of that advice back and forwards going to be made public as it gets to the point of determination, or is that largely just correspondence that's in between the planning department and Commonwealth agencies?
I would characterise it as largely being correspondence, part of the usual correspondence and discussions that we have with the Commonwealth. So, yeah, I guess at this point in time, we would not normally publish that material. But I'm happy to take that. I'm happy to take some of the detail on notice there.
If you could, that would be great. And the reason I ask this question is because we've made quite a lot of effort, this committee and also some of the individual members through Parliament and other freedom of information processes to get access to information around this project. Much of it's been considered cabinet in confidence and not provided. So I guess my second question to you is, would you consider that correspondence to be cabinet in confidence, given that it is really not about the consideration of cabinet, but rather the consideration of the planning assessment process?
Chair, I mean, if it's part of the usual course of conversations that we're having to do with our assessment, that there wouldn't be cabinet in confidence protections on that. I wouldn't have thought.
Okay, if you could come back to the committee and confirm the status of that, that would be useful, because I'm sure that there might be some efforts to try to see some of that information through the process.
Happy to take that on notice.
One of the issues that has been raised throughout this process is the requirement for free and informed consent of traditional owners. That's come about because of the Indigenous Land Use Agreement, but also the issues around World Heritage and obviously the cultural heritage implications there. Can you explain your understanding of the interaction of the Indigenous Land Use Agreement with this project, and whether or not you feel, or the department feels, that free and informed consent would be required before this project could proceed?
Chair, I guess obviously we take advice from Heritage New South Wales, and obviously they've made a submission which has been part of the process. I wonder if it might help that I actually refer you to Ms. Vanden Honet to talk a little bit more about how the department is looking to engage with Aboriginal groups associated with the project, which might help answer your question.
Thank you. I think you might be on mute, Ms. Vanden Honet.
Thank you, Mr. Ainsford. One of the things that the department has done has been to engage Aboriginal consultants called Murrawin to help us ensure that the registered Aboriginal parties and any Aboriginal stakeholders understood the environmental impact assessment process, which as we know is complicated, and to help them make a submission. And we have also reached out to those groups and expressed a desire to go on country if they would like to invite us. And we're waiting to hear back from them. And we will continue that engagement through the process to help us in our assessment of the proposal.
Can you just clarify, Ms. Vanden Honet, which Aboriginal parties have been engaged by your consultant at this point?
I'm sorry, I didn't hear the first half of that question.
If you could just confirm which Aboriginal parties have been engaged by the consultant at this point.
I will have to take the detail of all the names of the RAPs on notice and come back to you. Yeah, it's all right. I'll get back to you on that.
That would be great. I mean, we're now quite some time since the EIS was published. Submissions have obviously closed, so I'm just checking that they were all engaged in a timely fashion. And just to the question that I had originally asked Mr. Gainsford, what is the relationship in the mind of the planning department here between the Indigenous Land Use Agreement and the assessment process for this project? How do you see those two things interacting?
I might ask.
Ms. Vanden Honet might answer that.
I might take that one on notice and refer to our colleagues at Heritage New South Wales for their advice, unless Mr. Gaines has got anything
Sure.
to
I mean,
add.
yeah, they've obviously provided their advice, and this issue of free and informed consent has come up consistently through the process. I guess I'm just asking, ultimately, the part of government who will make a recommendation to the minister is free and informed consent of the registered Aboriginal parties and those parties that are party to the Indigenous Land Use Agreement required, in your view?
So Chair, yes, thank you for that question. So obviously the Secretary's environmental assessment requirements do require very detailed consultation and involvement of the Aboriginal groups, and that would be our expectation. The documentation that's been submitted, I guess, demonstrates the extent of work that was done as part of that work. Heritage New South Wales, as Ms van den Heunen was saying, has raised some concerns with the assessment, and for partly those reasons, we have engaged a consultant to help us come to an understanding around that engagement and making sure that there is the involvement of the right Aboriginal groups to do with the assessment process.
Right. Many of those groups have given evidence to our committee and have been highly critical of the assessment process to this point. I'm sure you're no doubt aware of that. What is the time frame around this consultant's work to be able to provide that advice back to you?
I might refer that to Ms van den Heunen.
So the answer to a previous question that you asked is we engaged Murrowan during the exhibition period of while the EIS was out on exhibition, so that they could assist any Aboriginal parties make a submission. Their engagement with us is ongoing for as long as we need it, which I anticipate will be through the process that we are at the moment, and then when the submissions report and preferred infrastructure report come in as well.
How many submissions do you think that engaging that consultant ultimately led to being made by various Aboriginal parties?
I do have the numbers. I just don't have them right at my fingertips, but I will try and get them and report back to you shortly.
Okay. Now, that obviously doesn't really, if that process was used to assist in the provision of submissions, it doesn't really go to this broader question about the land use agreement and sort of what happens next through this process. I'm sure that those groups will be keen to understand the response to submissions by the proponent, and should any additional information that relates to Aboriginal cultural heritage ultimately end up in the preferred infrastructure report, what will the department be doing to ensure that those communities continue to be engaged and be able to understand the process?
So thank you. I guess I'd reiterate my answer earlier, which is around the process that we'll use to determine whether the preferred infrastructure report requires a further exhibition, and as you're alluding to there, if that does include additional information that we feel would be worth putting on public exhibition, including Aboriginal groups, then we'll do that. But as a additional step, as Ms van den Heunen has outlined, we're doing that. We're looking to do that direct engagement with Aboriginal groups as well.
Okay. Well, just to confirm then, before I pass on to others, Ms van den Heunen, if you could come back on notice with the groups that were engaged by the consultant, that would be much appreciated. Thank you. I'll just go around the room. Deputy Chair, have you got any questions for these witnesses? Government members? Mr. Mallard? Bang?
No, okay, thank you.
Mr. Searle, you got any remaining questions from the opposition?
No, not at this stage, Mr. Chair.
And we may well have an 8-minute early mark. It's been a long session. I thank the witnesses for your time together and your persistence with some of the technical challenges with sound this afternoon. We had a good morning. We didn't have a great afternoon, but that's all right. A number of questions have been taken on notice. The Secretariat will be in touch with you about providing those answers within 21 days. Thank you very much for your time today, and that ends today's hearing.